Doc Talk. Yeah, we keeping it smooth. Your favorite paralegal got the legal groove. From the stars in the courtroom to your cousin's case, we breaking it all down. No rush, just pace. Hey fam, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. I know it's late, guys. I know it's late, but I tried to stay up to to get these docs, and I got the docs, and we are going to get into it. But before we do, if you have not done so, please hit the like button, subscribe to my channel so that way if I go live or if I put out a new video, you'll definitely get the notifications. And what else? Share this video. So today we have been watching the docket closely on the Karmelo Anthony case, and there was two motions that was filed. Now I know a couple of days ago I reported that they were filed. So when I say filed, it just simply means that we filed it through the e-file system. But I don't think that's what happened, so I misspoke. But either way, I knew that they were coming. Whether they was coming a couple of days ago or now, they have been filed. So the motion to recuse Judge Roach, as well as the motion for a new trial, has been filed today in Collin County, and I do have both of those motions. Now, when I tell you the motions are motioning, that's just exactly what I mean. Um, Together, these motions with the brief, well, the motion for a new trial is 193 pages, y'all. I have not gone through them. So I'm going to have the same reaction as a lot of you guys as far as any information that they did put in the motions. So just forgive me. I was able to get my hands on these, and so I wanted to present it to you guys. But before we get into that, definitely hit that like button and share this so I can be in the algorithm. But this case is very, very, very important. A lot of people now on all platforms, I have seen a lot of comments from both sides. I just want you guys to understand everyone are entitled to a new trial. They're entitled to an appeal. They can waive the non-criminal when you're dealing with the criminal side. Sometimes if you take a plea or whatever the case may be, and you sign over your rights, then you sign over your rights. And a lot of people don't even read to understand what they're waiving. So next time you find yourself in trouble, just make sure that you understand if you sign, I waive my right to a trial, just understand what you're waiving. Have your attorney explain that to you, okay? But everybody is entitled to an appeal, to file a motion, or well, in our case, you file a notice of appeal in order to start the appeals process. Now, there's two things that's happening. So, as of right now, this motion to recuse and this motion to for a new trial, they have from the date that it was filed, and I need to confirm. I don't know yet, but from what I was told, Judge Roach did what do we call it? I'm having a brain fart because it's so late in the evening. I don't want to say rejected. He refused, well, not refused, but he denied. There we go. That's the word I'm looking for. He denied the order. So what's going to happen is that motion to recuse and that motion for new trial is going to go now to the regional judge, and they're going to make a determination on it. They have within 75 days. 75 days. So if he did deny the order, then that means they have 75 days, within 75 days, to actually rule into this. Y'all give me 1 second. My boyfriend is calling. I need to answer. Give me a second. All right, my bad, y'all. My bad. Okay, so they have within 75 days in order to rule on this motion. Hello, hello, hello. Welcome, welcome, welcome. So, without further ado, I'm not trying to drag this out. Let's hop in. Now, I am going to be checking my likes, so I don't want to be sitting up here and y'all just over here just getting some information. Hey, if you like this video, that's good. If you dislike it, hit the thumbs down, but interact with me, okay? I am going to be reading because it's a lot. Now, I'm not going to go through all. Woo, we're going to see 193 pages on that new trial, baby. But we're going to get through it. If I have to do a part two, come on in the morning, I'm going to go ahead and do that. But let's get through this. Let's get through this. Hi, Kathy. I am happy that you are covering this. I am glad to even have you guys on here tuning in. So thank you guys for staying up. And you know what? I think I might, let me see if I can, I might have to put this down. So I don't know if y'all can see the chat, but I'm going to put it right there so that way at least y'all can see it. Okay? All right, so let me see. Hopefully y'all can see this. And y'all excuse my dogs because my dogs get on my nerves. All right, so let's get into this. So the first filing, let me see. This was at 8 a.m. Okay, so the first filing was the defendant's verified motion to recuse. Okay. They filed that at 8 a.m. this morning. The motion for a new trial and the brief in support, if you follow me on Facebook and Instagram. I briefly explained what these motions are. I try to give you guys the simplest terms so that way you guys can understand because I know it's a lot. It is a lot. It is a lot. And I know people are on YouTube. If you are on Facebook, definitely hit that like button. If you are on my true crime channel. Yes, I do have a true crime channel that I need to get out the way. And it's crazy. The last video that I posted was Karmelo Anthony's back April 4th, 2025. I actually reported on this. But I got into other things, work and all that other stuff, but I never lost sight of this particular case. And today I actually went back and listened to that video on my true crime and a lot of information on there. I was like, hold on. A lot of witnesses that they said, now mind you guys, this was fresh. So at that time, some of the kids went to the locker room so they can give their statements. And so a lot of things that they said in their statements, they retracted when it came to trial. And I was like, you got to be kidding me. But but if you're on that channel, definitely hit the like button and share and subscribe to that channel. All right, so let's get into this defendant's. Let's go to this one, the one that was filed at 8 o'clock. All right. I'm not going to go through this part. Well, no, I'm going to do it right. I'm going to do it right as if I was drafting it. So let's get into this. So I'm going to do a lot of reading. If y'all have questions, definitely ask them. I will try my best to answer them. Definitely send super chats or whatever the case may be. I would greatly appreciate that. All right. So comes now. Defendant Karmelo Sincere Anthony, by and through the undersigned counsel and pursuant to the Texas Rules of Civil Procedure 18A and 18B, respectfully moves to recuse the Honorable John Roach from presiding over the post-trial proceedings in this cause, including defendant's motion for new trial and brief in support, and defendant's objection to the closure of the proceeding and to any continued restriction of public access and motion for evidentiary hearing to clarify the record for appeal, both filed contemporaneously here within. Good Lord, they are not playing. The appeals team is appealing. In support, Mr. Anthony shows the following. And before you come over here hating or anything, just know I do have mods and they will boot you. That's number one. Number two, keep it respectful. I don't do none of that rah rah or hoo or whatever. I don't do no racist bigotry. I do not do ignorance over here. We're all adults and we can all have conversations. We will get you up here out of here really quick. All right. Same thing, Facebook and my other channel. All right. Let's get into it. All right. Timeless and procedural posture. Now, mind you guys, when we talk about an appeal, we're talking about procedural. What procedures did the court not follow, or um what did they miss, or anything, any legal errors? Okay, this right here, this motion is going to outline exactly what they are going after, what they feel that the court did not do, what the judge didn't do, whoever. Okay, we're about to go into that. And y'all excuse my child, he's a gamer in his room right next to mine. So, all right. So, a jury found Mr. Anthony guilty of murder. And on June 9th, 2026, the court imposed sentence in open court, assessing 35 years confinement. Contemporaneously with this motion to recuse, Mr. Anthony has filed defendant's motion for a new trial and brief in support and defendant's objection to the closure of the proceedings and to any continued restriction of public access, and motion for evidentiary hearing to clarify the record for appeal. Those filings require fact finding concerning the court's access order, courtroom capacity, public seating, overflow access, record restrictions, and the court's post trial public statements. A notice of appeal has been filed. The grounds for this motion to recuse arose after trial as set forth below. This court remains authority over the post trial proceedings. A notice of appeal does not divest the trial court of jurisdiction to conduct post trial proceedings, including a hearing to settle and clarify the record and a timely motion for new trial. That authority continues through the 75th day after sentencing and until the appellate record is filed in the Court of Appeals. Let me just make sure. Because the Honorable John Roach is the judge who would preside over the requested evidentiary hearing and rule on timely motion for new trial, recusal is properly sought now. And when you see these right here, they're referencing other case law to support whatever it is that they're talking about in these paragraphs. So, just FYI. This motion is timely. A motion to recuse must ordinarily be filed at least 10 days before the hearing at issue, where, as here, the grounds for recusal arise after trial. The motion must be filed at the earliest practicable time after the movement learns of them. And they're once again quoting case law and where the motion was filed at the earliest. So hopefully y'all get the drift. All right. The motion must also be verified and must state with particularity the grounds why the judge should not sit on personal knowledge and setting forth facts that would be admissible in evidence. This motion satisfies each requirement. The undersigned counsel entered an appearance in this cause on June 23rd, 2026, and first became aware of the interview described herein on that date. This motion is filed at the earliest practicable time thereafter, before any hearing on the motion for the new trial has been set or held, and before any ruling on that motion. All right, now we're getting into the good stuff. So, why are they calling for a recusal of John Roach? After, and if y'all have been following me, I have been trying to break it down step by step of things, and it's not what I feel, it is based off of the Texas rules of criminal procedure, the canon statutes, the ethics, Texas ethics for judicial conduct. All of that is what I pull from. So all of this you're going to be familiar as to what I was saying. I just don't be talking out my behind. No, I actually pull. That's one of my things as a paralegal. One of my duties is to do legal research. So when I draft these pleadings, I have to also know what I'm talking about because that's what attorneys rely on paralegals to do so. Okay. All right, grounds for recusal. After the jury returned its verdict and the court imposed sentence on June 9, 2026, the Honorable John Roach, the presiding trial judge at trial, granted a televised interview to WFAA TV Channel 8 concerning this case that aired on or about June 11th, 2026. In that interview, Judge Roach expressed personal opinions about the propriety and correctness of the jury's verdict, the fairness of the trial, and the correctness of the judge's own rulings during the trial. Such conduct implicates the Texas Code of Judicial Conduct and the objective appearance standard under Rule 18B. And I'm saying that because I told you guys. The case remains a pending or impending proceeding before the court at this time, and public statements expressing the judge's personal views on this matter would suggest to a reasonable person the judge's probable decision on any motion for new trial that may be filed. Recusal is therefore necessary. Among the problematic comments that Judge Roach made during the WFAA TV interview are the following. Judge Roach endorsed the jury's guilty verdict. When asked by a reporter, did the jury get it right? Judge Roach answered, yeah, they did, explaining that the jurors were picked based upon the law and listened to the facts that happened here in this very courtroom, and added that whatever they say, they get it right. B. Judge Roach characterized Mr. Anthony as a nice young man who committed a crime and understands today the consequences of committing a crime like he did, and declared that Mr. Anthony had received a fair trial, stating, I certainly think he did. Y'all see how they picking apart? This is what a good appellate team does. Whether y'all like it or not, they have a job to do. And I hope that in the event one day that you are in a criminal setting going before the judge and you don't have your way, you better find you a good appeals team just like this. So, regardless if y'all don't like it, I don't know what to say. Okay. Judge Roach defended the courtroom access and no streaming restrictions that the motion for new trial challenges, calling the decision not to allow cameras or streaming any an easy decision, asserting that the general public had access to the courtroom, stating that of the 70 seats in the courtroom, he only had 200 requests by the media, and that the public had only 27 to 32 public seats that we rotated every day, maintaining that members of the public could have stood in line with everybody else to obtain one, and concluding that he had stuck the balance pretty well. D. Judge Roach addressed a suggestion then circulating in social media that he had a personal relationship with the family of the deceased, denying that he knew the Metcalf family, disputing the authenticity of images said to show otherwise, which appeared to have been fabricated, and volunteering that he sympathized with the Metcalfs and what they've been through. E. Judge Roach addressed his rulings during his jury selection. When asked about the defense's objection to the dismissal of three prospective jurors who had identified as African American, Judge Roach stated that he followed the law in that case and did it to a T, that he was proud of that, and that although he knew in the back of his mind what the perception was going to be, he was not here to satisfy perceptions. Judge Roach reiterated this public defense of his own rulings in a written statement to Fox News, in which he stated, I understood the public's desire to know what happened in the courtroom. The overwhelming focus on my ruling regarding the media in the courtroom was to protect the process, witnesses, and jury. Now that the trial is over, it is important to me to provide transparency. A verified transcript of the interview is attached as Exhibit A. Oh, we got exhibits. The recording of this interview is filed conventionally with clerk as Exhibit C. And you guys, well, I only showed a snippet, but I can show y'all where to go to actually watch that whole interview. Judge Roach's written statement to Fox News is attached as Exhibit D. Throughout the trial proceeding, an order prohibiting extrajudicial statements, the gag order, entered July 28, 2025, barred every other participant in this case. All parties and their attorneys, witnesses, expert consultants, agents, and spokespersons, and law enforcement personnel, courthouse and court staff, and court appointed officials from making any extrajudicial statements that addresses the character, credibility, expected testimony, guilt, or innocence of any party or witness. That discusses the anticipated evidence or that is intended or likely to influence public opinion. The court grounded that restriction in its own findings that extrajudicial publicity posed a risk of imminent and irreparable harm to the right to a fair trial. By its terms, the gag order governed the proceeding through the conclusion of the trial. The court's interview followed sentencing, and Mr. Anthony does not assert that it breached that order. What matters is not any breach, but the principle the court itself announced in the I'm sorry, announced in entering the order. The public commentary on a pending criminal proceeding threatens the fairness of that proceeding. And they actually have the gag order. Hold on. Okay, so we're on page 4. Let me see. Exhibit B. Because we don't even know what the gag order looks like. Let me see. I don't want to go. That's the thing. Okay. Hello. Hello. Nice to see y'all drop in. Don't forget to hit that like button if you have not done so. All right, here's the order prohibiting extrajudicial statements. So purpose and authority. Ooh, hold on. Let me my night light on my computer because baby, I'll be in the bed by 10 o'clock. And so when this little thing dims, that means it's time to go night night. I read all day, all day. Okay. Purpose and authority. So this is what the gag order says. This is our first time looking at this gag order. Well, for me it is. The purpose, the court finds that extensive pretrial publicity poses a serious risk to the fairness of the trial. Pursuant to the inherent authority of this court and consistent with the United States and Texas constitutions, the court orders the following. Parties subject to order. This order binds the following individuals and entities, all parties to this action and their attorneys, witnesses, expert consultants, agents, spokespersons, law enforcement personnel, courthouse, court staff, and court appointed officials. Prohibited. Unless first approved in writing by the court, no covered person shall make any extrajudicial statements that addresses the character, credibility, expected testimony, guilt, or innocence of any party or witness. And now this is the gag order that they put in place, mind you. Discuss evidence anticipated to be introduced at trial, identifies or comments on jurors, jury selection, or deliberations, intends or is likely to influence public opinion and potential jurors. Again, I'm going to say this is the gag order that this court put in place. These restrictions apply to statements made via any public medium, including traditional news outlets and social media. Permitted communications, allowed communications include procedural announcements, hearings, schedules, court filings, statements required by legal or ethical duties, advising clients of the rights. Court findings. The court finds media coverage has the potential to cause imminent and irreparable harm to the defendant's right to a fair trial. Alternative measures, venue change, jury screening, let me see, would be inadequate alone. Narrowly applied speech restrictions are necessary to protect jury impartiality. Duration. This order shall remain in force until verdict or until written order of this court. Sanctions for noncompliance. Any violation may result in contempt, fines, attorney discipline, or other remedies as the court judges appropriate. And notice and certification. Within 7 days of this order, counsel for each party shall suffer. Okay, yeah, that's just certificate of whatchamacallit. All right, so y'all got that. This is the gag order. And I see, hey, Marius, I know that you're off of Facebook. So those who are tapping in from Facebook, what up, what up, what up? All right, so let's go back to page 4. All righty. Throughout the trial proceedings, an order prohibiting extrajudicial statements, what we just read, entered July 28, 2025, barred every. Did I already say that? Oh, I think I already read that. Yep, I did. All right. So the same judge who imposed silence on the defense, the state, and all other participants on the express premise that public commentary threatens a fair proceeding therefore spoke publicly about this case, endorsing the verdict he is being asked to set aside and defending the access rulings now challenged, all while retaining the authority to preside over the post trial proceedings still before him, including the requested evidentiary hearing and a timely motion for new trial. What people aren't understanding, and I don't know why, and I don't know, y'all know me, I try to break it down in the thank you, thank you, thank you. Oh, y'all. Oh, thank you, LP. Y'all awesome. Y'all are awesome. Thank y'all. LP and I don't know who is this zoned out entertainment. Thank you guys. So, what I was saying was a lot of people did not understand the difference when you file that notice of appeal, okay? That notice of appeal starts the process. So it made and I was battling people all on Facebook. Y'all have to understand if you go to the docket, if the case was closed, it will say closed. Okay? The case status says appealed. Therefore, because that notice of appeal was filed, that means that there is a case pending. And Canon 3 that I gave to y'all, I showed y'all, of the Texas Code of Judicial Conduct says that if a case is pending, you have violated that code. That's what I was trying to get people to understand. People ain't understanding. Hey, Marius, what's up? What's up? Hey, y'all that just tuned in. How y'all doing today? Hope y'all doing fine. Y'all go ahead and hit that like button, share this live. Yes, I'm gonna see how long I can go, y'all. I might have to do part 2 in the morning. I got my Mexican Coke right here, my bottled water. We in there. All right, so I just wanted to say that. In his contemporaneously filed objection and motion for new trial, Mr. Anthony contends that the management of courtroom security and capacity led to the denial of a public trial. Judge Roach's own public statements reflect substantial personal involvement in the logistics and access decisions now at issue. In his post trial WFAA interview, Judge Roach stated that he had been prepping for this trial with county departments, the Collin County system, the sheriff's office, and others for about 8 months. In his June 17, 2026 public letter, Judge Roach described the involvement of multiple county agencies and offices in the trial's logistical administration. These facts reinforce why another judge should decide the post trial motions based on documentary evidence, testimony from non judicial witnesses, and a record made in open court, rather than requiring the respondent judge to evaluate the legal effect of his own disputed public explanations and access related decisions. Yes, girl. LP, hey. Hey, let me tell you, I was drinking Coke, and then my boyfriend, if y'all don't know, he's Mexican and Honduran, and baby, he put me on to the authentic tacos and the Coque Mexicana, and I fell in love ever since. With both of them. All right. Well, all three of them, him and the tacos, and yeah. But anywho's, let's go here. The interview was not Judge Roach's last public word on this case. On June 17th, 2026, after sentencing, while the court retained authority to decide a timely motion for a new trial and the cause remained subject to direct appeal, Judge Roach published a signed public letter about this prosecution on Collier County's official government website under the title Thank You Letter from Judge John Roach. Addressed to the members of the Collin County family, Judge Roach speaks of the recent trial of State of Texas versus Carmelo Anthony as a finished undertaking and closes by calling that service one of the great honors of my judicial career. Judge Roach further tells the public that those who worked on the case contributed to ensuring the process was conducted fairly and very question a motion for new trial challenging the conduct of the trial that would put before the court to decide. A judge who publicly memorializes the trial as concluded and publicly pronounces the process fair while still holding the authority to grant a new trial signals to a reasonable observer that he regards the matter as closed, which that's the reason everybody's saying, oh, it's closed, oh, it's closed. Baby, it's not closed, it's appealed. If it was closed, it would say closed on the docket. That Judge Roach did so once more in public forum after having used the gag order to restrict every other participant public commentary throughout trial, sharpens rather than softens the appearance that the court no longer sits as a neutral arbiter of the post-trial proceedings that remains before it. In my opinion, I think they should just do a change of venue, baby. Take it to Dallas County. It's fair over here. And side note, if you guys have not seen my little four-part series of Inside the Collin County's DA's office with Greg Willis and who is that, Bill Worski, it was going down in that office, and I feel bad, and I hope that there are no other victims left, and I hope that things have changed within that DA's office because it was nasty over there. It was very nasty. So y'all go over there and check that out this week. All right. Standard and argument. I'm trying to figure out. No, I want to read this because I want you guys to understand. For those, most of y'all who've been with me, y'all understand. There's others that want to argue all on Facebook and YouTube and TikTok and Instagram about this. This is their argument that they're trying to make. A judge must recuse where his impartiality might reasonably be questioned. A judge must recuse in any proceeding in which the judge's impartiality might reasonably be questioned or in which the judge has a personal bias or prejudice concerning the subject matter or a party. And they gave you the Texas Rule of Civil Procedure. Y'all can go, y'all can type it in or whatever, and you can read it for yourself. This is not something that they're pulling out of thin air. Based off of this code, is telling you what the judge might do. If he has a personal bias or prejudice concerning a subject matter or a party, if you look at the interviews, certain things he should not have said. If he didn't say certain things, then I don't think we would be here in regards to that. But you have to pay attention. See, a lot of people just want to go instead of actually do the research themselves. I just put it out there and I show you where to get the information from. But if you choose to be oblivious and not comprehend what I'm putting down, then that's on you. You are very welcome. You are very, thank y'all for tuning in. Thank y'all for tuning in. All right, let's get back to this. These procedures apply in criminal cases. The standard is objective. The question is not whether the judge is in fact biased, but rather a reasonable member of the public at large, knowing all the facts in the public domain concerning the judge's conduct, would harbor a reasonable doubt that the judge is impartial. Let's go here. Applied here, a reasonable observer aware that the presiding judge, during the Rule 21 period in which a motion for a new trial could be filed and before his authority to rule on a timely motion expired, gave a public television interview endorsing the verdict and defending the challenged access rulings, the very matters a timely motion for a new trial would ask him to set aside, would reasonably doubt that the judge could impartially decide that motion. The objection is not that, hold on, let me reread that. The objection is not that the motion for new trial challenges the court's ruling. Every such motion does. It is that the court publicly vouch for the correctness of those specific rulings outside the courtroom before it was called upon to decide the motion. Okay? Everybody got that? Oh yeah. Oh yeah. And that's the whole purpose. And it's not just Texas. It's also any other state. Each state has a rules that everybody has to follow. The judges have to follow, the attorneys have to follow, the citizens have to follow. It's not that hard, people. And mind you, 2021, or no, 2018, he actually was sanctioned for, I think, promoting a book him and his wife wrote. So if he was so, and I'm not trying to put the man down, but there's people out here fighting for their dear life talking about he is squeaky clean. Okay, if that is the case, he should be very well of the Texas Code of Judicial Conduct. That's all I'm going to say. That's all I'm going to say. My hope is that if a new trial is granted, his attorneys will file for a change of view. I do hope so. It's definitely something that needs to be considered. All right. Let's see. B. The court's extrajudicial public commentary on this case requires recusal. The basis for this motion is the court's extrajudicial public statements about this case, not its rulings. People got to get it in their head. Ain't nobody talking about the rulings. We're talking about things that the court did that they should not have done. Under Rule 18A, a judge's rulings may not be the sole basis for a recusal, but the comment to the 2011 amendment makes clear that the term rulings is not meant to encompass a judge's statements or remarks about a case. Bias or prejudice arising from an extrajudicial source is a common basis for recusal. And they quote, what is that? White Lidicky in United States, Kemp versus State. Okay, so the question, however, is not whether the court learned the facts of the case from a source outside the proceeding. It is that the court made extrajudicial public statements that objectively appear to commit it to the verdict and the challenge access rulings while it still retained authority to decide a timely motion for a new trial attacking those very matters. So, in other words, y'all, he should just waited till the time expired for a motion for a new trial to be filed and then do what he was going to do. But he didn't. I don't even know if he even looked at the docket or if anybody told him, hey, a notice for an appeal was filed the very same day or the day after. Um, let's see. Where would I? The question is, the contrary limitation that a judge's in case rulings, remarks, or actions will only rarely support recusal has no application here because the ground is not anything the court did in the courtroom, but what is said about the case outside of it. Okay, so we're talking about what was done outside of the courtroom, not inside, outside of it. Where the principle that an extrajudicial source supports recusal has been applied to the judge's public commentary about a pending case, courts have required disqualification as set out below. Most pointedly, the court publicly defended the very courtroom access restrictions that Mr. Anthony challenges as having denied him a public trial, the subject of his contemporaneously filed request for an evidentiary hearing and motion for a new trial. The court has now publicly characterized the same restrictions as proper and asserted that the public had access to the courtroom. The court would thus be required to rule on a challenge to its own rulings after publicly committing in the media to those rulings' correctness. A reasonable member of the public, aware of these facts, would harbor far more than a reasonable doubt that the court did impartially decide that challenge. Nor was the court's public defense of its rulings limited to the access restrictions. The court also defended its rulings during jury selection, declaring that it followed the law and did it to the T. That a judge would take to the media to vouch for correctness of his own contested rulings, while review of the rulings remains to be sought, is is at the core of what the objective standard forbids. Those rulings are not merely challenged. A published decision of the very court that reviews this one has since held that a comparable space-based closure of jury selection imposed without Waller findings or consideration of reasonable alternatives violates the right to a public trial and requires a new trial. If y'all want to see that, y'all better screenshot and look up these cases. And let me see, for that court, that the court publicly vouched for the correctness of the rulings now challenged under recent published public trial authority from this court of appeals only sharpens the appearance that it has committed itself outside the courtroom to a position it must now revisit. The court also publicly endorsed the correctness of the very verdict the motion for new trial asked it to set aside, stating that the jury reached the right result and that Mr. Anthony committed a crime. A judge who has publicly proclaimed the verdict correct cannot be expected to impartially decide a motion seeking to set the verdict aside. The standard that governs judicial public comment confirms the appearance problem. The Code of Judicial Conduct provides that a judge shall abstain from public comment about a pending or impending proceeding which may come before the judge's court in a manner which suggests to a reasonable person the court's probable decision on any particular case. Uh, Texas Code Judicial Conduct Canon 3B, paragraph 10. Did I not show this to you guys? Did I not show this to you all? I specifically showed y'all this particular code, and they swore up and down, no, there are codes. This is a whole judicial conduct code that he failed to follow. It lays out the rule in simplest terms. But I had to think, oh, back in 2018, he did the same thing. He violated. And guess what they did? They actually dropped it too. I forgot what the world they did. He still got in trouble, but not in as big of a trouble as he should have been for violating, I think it was Canon 2, if I'm not mistaken. But I showed y'all this already. Although the canon does not bar a judge from explaining court procedures for public information, I got to read that slow because some people don't understand. Again, although canon does not bar a judge from explaining court procedures for public information, this was not a neutral procedural explanation. The court endorsed the verdict, stated that Anthony had committed a crime, declared the trial fair, and defended the very access restrictions Mr. Anthony now challenges. That principle reflects the same concern that drives the recusal inquiry. The public confidence requires a judge not appear to have resolved outside of the classroom a matter that is still before him. Mr. Anthony does not contend that the court should be disciplined. The point is narrower. The court's public endorsement of the verdict in defense of challenge rulings on a matter that remained pending, with the post trial proceedings yet to be decided and the case subject to appeal, is precisely the kind of comment a reasonable observer would understand to signal the court's view of the very questions it must now decide. Recusal does not turn on labeling the court's conduct a bench of any rule. It turns on the objective appearance standard. Mr. Anthony does not rest on any rule violation. A violation of a canon of judicial conduct will not, standing alone, support recusal absent the requisite showing. The controlling question is objective, whether the court's extrajudicial public commentary would cause a reasonable member of the public to doubt the court's impartiality. Under that standard, the court's public commentary is strong evidence on the appearance inquiry under Rule 18b B1. The asymmetry lies at the heart of this motion. By written order, the court found that extrajudicial publicity posed a threat of imminent and imperishable harm to the fairness of this proceeding, and on the finding, it silenced everyone else with a stake in the case: the parties and their counsel, the witnesses, and even law enforcement personnel, court staff, and the court appointed officials who spoke for the court. Then, with every other participant bound to get off my, oh Lord, I gotta fly out my darn Mexican coat, Lord. Then, with every other participant bound to silence the court's own command, the court alone stepped before the cameras and spoke at length about the very case it continues to adjudicate, ensuring the verdict and defending the challenge rulings. A judge who declares public comment on a case so dangerous that all others must be silenced, and who then reserves the commentary to himself while the case remains before him, does not appear to a reasonable member of the public as a neutral arbiter the law requires. That asymmetry standing alone casts reasonable doubt on the court's impartiality in deciding the pending post trial matters. Let me see. So Chris says, I know this is not on the subject, but if he gets a new trial, will the people that lied on the stand get in trouble? That's a very good question. I mean, at the end of the day, when you go before the court, you are under oath. And when you lie under oath, you do commit perjury. And perjury has its own consequences for that. So we just have to see. We really have to see at this point. Federal courts applying the I'm not even gonna my brain fart. Appearance standard of 28 of the United States Code section 455A have treated a judge's public comments on pending newsworthy litigation as a serious recusal problem. Rule 18b B1 mirrors that very same code, and decisions construing that provisions are pervasive here. In United States versus Cooley, a judge presiding over pending matters appeared on national television and expressed his resolve as to how they should be resolved. The court held disqualifications required because the appearance was that the judge had become an active participant in the case instead of a detached adjudicator. Now, do y'all see that? United States versus Cooley. That's interesting. So y'all see what happened in that case? That's why when we draft these, you have to ensure that you find other cases similar to support whatever it is that you're trying to do in your motion. So this thing is 45 page, well, probably with the exhibits, probably 30 something pages with the exhibits, but that's what you have. This is not something you're not using AI, and I please don't use AI for court filings. Cause I've seen some stuff. I'm like, I'm not submitting this on your behalf. No, absolutely not. Let me see. Replying. Okay. All right. So I see that you're replying. Let me see. I think he was reprimanded without admitting to any wrongdoing, using his office to promote a book and to steer his. Yeah, that's what he did. They actually dropped it. It was one thing. I have to go back, and I said it in one of my videos, but it's past 10, child. I'll be asleep. But yeah. Let me see, where was I? Okay. In In a read of Boston's Children First, a judge gave a newspaper interview about a pending high profile case, and the court ordered disqualification, cautioning that judges must be particularly cautious about commenting on pending litigation in newsworthy cases. I love the case law that they're putting in here. Those decisions describe this case. A judge who granted a televised interview about one of the most closely watched prosecutions in the state of Texas, endorsing the verdict, pronouncing the trial fair, and defending the very access rulings under review, has assumed the posture of an advocate for his own judgment rather than a neutral arbiter of the motion that challenges them. C. Now we're still under what is this? Paragraph 2 or section 2, I would say, of the standard and argument. So these are the arguments that they're making. C reads, the court publicly endorsed positions on issues it still had authority to decide. Mind you, it was still in that time frame to where a motion could have been filed. And so because he did, but let me get the reading. Mr. Anthony's conviction is now pending on direct appeal before the Court of Appeals for the 5th District of Texas at Dallas. Shout out to all my Dallas family, even though I'm from South Carolina, but I've been in Dallas since 92. Shout out to y'all. If y'all have not liked this video, share it, subscribe to my YouTube channel. If you are on Facebook, definitely like and share this, and come on over to YouTube and subscribe. So that way, if I go live or y'all get, if I make a new video, y'all can definitely get notifications. All right. So the trial court retains lawful authority over a timely motion for new trial, notwithstanding the notice of appeal. The appearance problem is therefore not one of jurisdiction. Mr. Anthony gave notice of appeal on June 10th, 2026, the day after sentence was imposed and before the court set for its televised interview. With the appeal already initiated and before any appellate brief was filed or any reviewing judge had written a word, the court went on television and pronounced its own rulings correct and the verdict sound, reviewing and affirming its own decisions in the court of public opinion, ahead of the very courts to whom that review belongs. A trial judge, a trial judge's public review of the merits of his own rulings while the court retains jurisdiction with the post-trial proceedings yet to be decided, the notice of appeal on file, no brief yet written, and no appellate judge having spoken, underscores why a reasonable observer would doubt that the court could now impartially preside over the post trial proceedings, including a timely motion for new trial. A reasonable member of the public would regard a judge who publicly vouches for the correctness of his own judgments, while those judgments await the considered review of a higher court, as having exchanged the neutrality of the bench for advocacy of his own work, and would doubt that the same judge could impartially preside over the post-trial proceedings that remain before him. The need for recusal is brought to a point by proceedings that now lie immediately ahead. Mr. Anthony has objected to sealing Mr. Anthony has objected to the sealing of the court file and has asked the court to convene an evidentiary hearing to establish, for the record and for appeal, how the trial was structured and closed, and how, when, and by what authority the court's file and the reporter's record were sealed and withheld. Those are inquiries into the court's conduct. The judge who imposed the closure, direct the sealing, and then publicly defended would be asked to preside over a hearing, receiving evidence about the propriety of these very acts, and, in the motion for a new trial to follow, to decide whether they require a new trial. A reasonable member of the public would doubt that the same judge could sit impartially as the fact finder of the lawfulness of his own challenged decisions. That doubt itself reason to refer this matter so that a different judge conducts the hearing and decides the motions and depend on it. And before I get to the next one, if you have not seen my recent posts, y'all, I don't know where this information is coming from, but there was information that the court reporter's transcripts, is $10,000, and that the case is now stalled, or the appeal is stalled, or at a standstill. Y'all, stop it. Stop with the misinformation. He filed for an indigence, unable to pay for court costs, and affidavits for an inability to pay court costs, or afford an attorney. So whenever you file those type of affidavits, right, you get your court records for free. I'm just saying. So we got to stop with the misinformation. Also, personally, I would not be sending my money unless it comes directly from the appeals team. If any 6 of those attorneys put out something that say, "Hey, we are looking for donations," then by all means, give your money. But as of right now, they have not publicly came out and said anything. That's number 1. Number 2, they have no issues with getting that court reporter transcript or the clerk records from the trial court because he filed the affidavit. I There is further dimension to the court's public commentary in taking its defense of its own rulings to the press. The court spoke not as a private citizen, but with the authority of judicial office, lending that authority to a one-sided public account of case it must still decide. The effect is to convert a matter committed to orderly adjudication into the public contest, one in which Mr. Anthony must either answer the court in the media or allow the court's public endorsement of its own rulings to stand unrebutted while the same court continues to preside over the motion challenging them. A reasonable member of the public would not regard a judge so situated as the neutral arbiter that the law requires. D. The court also took to the airwaves and answered a suggestion of its own partiality that no party had raised. Mr. Anthony does not allege that the court had any relationship with the family of the deceased. I'm going to repeat that. Mr. Anthony does not allege that the court had any relationship with the family of the deceased. That is y'all on the internet. Y'all on the internet. Y'all on the internet. The social media material suggesting such a relationship appears to have been fabricated, including by artificial means. The point is not the truth of that suggestion, but the court's response to it. Rather than allow a non record rumor to remain outside the proceeding, the court used its televised interview to answer a suggestion of its own partiality that no party had raised. So that question, are you related to the Metcalfs or are you friends? That didn't come up by Mr. Anthony or the state of Texas. Y'all have to realize that what goes on the outside does not affect anything that goes on the inside unless it is in writing, in paper, submitted as an exhibit, on a transcript, whatever the case may be. So y'all said that, not him. But that's not the point. The point was how he responded. All right, going back to this, rather than allow a non-record rumor to remain outside the proceeding, he should just not said anything. The court used it as a televised interview to answer a suggestion of his own partiality. I already read that. Denying any relation. I already read that too. Oh no, I didn't. Okay, let me stop. Rather than allow a non-record rumor to remain outside the proceeding, the court used its televised interview to answer a suggestion of its own partiality that no party had raised, denying any relationship with the family and in the same setting, volunteering that it sympathized with the Metcalfs and what they've been through. See, that's where he messed up at. That's exactly where he messed up at. In stepping before the cameras to defend itself against any extrajudicial allegation and to express sympathy for the family of the deceased while the Rule 21 period remained open, post trial relief was impending, and the court still retained authority to grant a new trial. The court assumed the posture of the participant answering a charge rather than a detached adjudicator. The governing question is objective: whether the court's conduct, viewed by a reasonable member of the public, conveyed an uncommon interest and degree of personal involvement in the case. In Cooley, United States versus Cooley, a judge's volunteer television appearance to speak about a pending high profile matter unavoidably created the appearance that the judge had become an active participant rather than a detached adjudicator, such that a reasonable person would harbor a justified doubt as his impartiality. I'm going to break this down in the most simplest terms. I'm a notary. And one thing I teach my notary adult learners is that you are impartial. You have no interest in whatever it is that you are signing. So let's take loan signing for instance. If I go to a loan signing, I'm impartial in that matter. I don't have any interest in them getting that loan to close on that loan to, for that house. You have to be impartial. If I knew them, and let's say that I know that eventually they was going to sell the house to me or whatever the case may be, somehow I'm connected, I'm no longer impartial. I have to remove myself and get another notary to handle that loan signing. That's what's happening here. So in United States versus Cooley, it was a high profile matter. The judge talked about it. So now you're a participant. Your job as a judge is not to participate. Your job is to apply the law. Right? The legislative branch make the laws, judicial applies the laws, executive execute the laws. That part. That's your job. The First Circuit ordered disqualification on materially similar facts when a judge gave a press interview about a pending newsworthy case. A judge who goes on the television to deny a personal allegation and to express sympathy for one side's family while the Rule 21 period remained open and post-trial relief was impending conveys the very personal involvement those decisions describe. So we're not saying that you related to the Metcalfs. What we're saying is when you gave your interview, you sympathize for one family, one side. And you did that while it was an opportunity for a motion for a new trial to be filed. Okay? Yes, 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 LP. Oh, thank you. We trust only you for the real news and the information on the case. You and Attorney Gray. Thank y'all. There's a lot more people out here, but I know I'm a small channel, and my goal is not to be big as anybody else. My whole purpose of my channel, I don't know why I still got that trigger warning on there. That's when I was doing that Greg Willis stuff. But yeah, so my sole purpose is to put out the facts. If y'all don't see me pull up a court document, or y'all don't see me look at the court docket, or y'all don't see me pull codes and laws and statutes, I'm not going to report it. I mean, I report it on my Instagram because I know I have the document. And I just don't sit there and read every document on my channel based off of what I post, because I would have content for days. I just try to do things that I feel is important. Like this Carmelo Anthony case for me, this is not something that, I'm going to sit there and, yeah, and I know I did pop up at the time, but I was like, I need to speak to the masses. What can we do? And since I have this platform, I might as well utilize it. Like this here is a big problem. I used to live in Collin County. No, unfortunately, no, I didn't go to the courthouse because I had to get attorneys ready for trial in the own cases that I'm whatchamacallit. So I can't take out my time to go to the courthouse on a criminal trial when I have attorneys that need to get ready for trial. I'm the only paralegal they got because I'm your favorite paralegal. I'm the best. But that's neither here nor there. So no, this is not something that I just popped up because it was popular. No, I'm actually passionate about what goes on in my community. I'm passionate about what I do as a paralegal. And I feel in any capacity that I'm in, I feel like I can bring awareness, and I can at least break down for you guys in the simplest terms so that you guys can understand. Because I know everybody is invested in this, and we're trying our very, very best to see or to get a positive outcome. All right. All right. Let's see. The ground is of a piece with the closure it accompanies. This ground is of a piece with the closure it accompanies. Okay. The court sealing of the record and its restrictions on public and press access created the information vacuum in which such rumors couldn't take hold. The court then used the press access. The court then used the press access it had reserved both to refute the rumor and to justify the access restrictions that produced it. The objective appearance is of a judge managing the public narrative of his own case from both directions. Standing alone, this threat is the most modest of the grounds stated above, and Mr. Anthony presents it not as an independent basis for recusal, but as confirmation of the personal involvement and want of detachment, the court's endorsement of the verdict, its defense of the challenge rulings, and its public review of its own judgments already established. See, it's not about, how can I say this? Everybody, I don't, you know what? I don't even want to get into it. We'll be here all day. The second argument, no, not the second. Wait, A, B, C, D, E. The fifth argument. Due process reinforces the need for impartial decision maker. The court need not reach constitutional due process. Rule 18b B1's objective appearance standard is sufficient. Due process confirms the importance of an impartial decision maker and the principle that recusal is required where the probability of actual bias is too high to be constitutionally tolerable. But the relief requested rests on the Texas recusal rules. At a minimum, the circumstances counsel strongly in favor of referring this motion so that a different judge decides both the recusal and the post-trial proceedings, including a timely motion for a new trial. Let's see, separately and in the alternative, to the extent the motion for new trial requires fact finding or courtroom capacity, the volume of the media request, and I put in my media request, baby, public seating and its rotation, the feasibility of an audio feed, and the reasons reasonable alternatives were rejected, the court's own public statements reflect that it possesses personal knowledge of disputed evidentiary facts concerning the proceeding, an independent circumstance that reinforces recusal. So, this is the relief that they're requesting. Mr. Anthony requests that the the Honorable John Roach, within 3 business days of this filing of the motion, either sign and file an order of recusal or sign and file an order referring this motion to the presiding judge of the First Administrative Judicial Reason for assignment of a judge to hear and determine it. Because the motion is filed after evidence was offered at trial, Mr. Anthony recognizes that Rule 18A F2B and not Rule 18A F2A governs so that the respondent judge may proceed unless stayed. Mr. Anthony therefore further requests that the presiding judge of the First Administrative Judicial Region or the assigned judge immediately enter an interim order under Rule 18AG4, staying any ruling on the motion for new trial until this motion is determined, and set this motion for hearing as soon as practicable so that a neutral judge may hear and rule on the motion for new trial before the court's authority under the Texas Rules of Appellate Procedure 21-8 expires. Mr. Anthony seeks this expedited determination not to delay, but to permit a neutral judge to decide the motion for new trial within the time the law allows. And that's Texas Rules of Civil Procedure 18A, F, and G. Time is of the essence. This court's authority to rule on a motion for new trial expires by the operation of law on the 75th day after sentencing, and the deadline continues to run during referral and reassignment. Mr. Anthony therefore respectfully requests that referral, assignment, and determination of this motion proceed on an expedited basis so that the judge to whom this motion is assigned may hear and rule on the motion for a new trial before it is overruled by operation of law. In other words, before it expires. By separate cover, Mr. Anthony has requested expedited assignment from presiding judge of the First Administrative Judicial Region. Woo! That is a tongue tire for you. Prayer. He respectfully prays that this motion be granted, that the Honorable John Roach sign an order recusing himself, or in the alternative, refer this motion to the Honorable Ray Wallace, who is the presiding judge of the First Administrative Judicial Region, for assignment of an impartial judge to hear and determine this motion and Anthony's motion for a new trial, and that Mr. Anthony have such other further relief to which Mr. Anthony may be justly entitled. So, once again, if you file a motion, you have to set it for hearing. So that means that the attorneys will have to go before the judge and they will have to present their arguments. They already did in the motion, but they have to go before the judge. Okay. All right. Whew, Lord, we were just on page 13. Let me see. Okay, that's the verification. They just see all right, and I'm gonna explain this to you guys also. So I don't think I've ever have to do that in other states. I just realized that. But like in Texas, when we're filing records, transcripts, financial statements, we have to do what's called an affidavit. And we have to make, we have to, well, how can I say this? So if we, for instance, go get a record, whoever the custodian is, they have to complete an affidavit to say, okay, this is true and correct. This is a true and correct copy of this record. So you want to ensure that in court, If you want to prove up anything, you better have your affidavits. All right. So I think these are just the exhibits, the transcript, the video, the written statement. Okay. We ain't got to go through all of that. All right. If y'all want the transcripts, y'all just email me and I'll send it so y'all can read it to yourself. Now, this right here, this motion for a new trial, baby. We might have to come back tomorrow for this. I'm gonna read some of it, but we might have to put pause in it. And if y'all loyal, y'all come back and y'all listen. But let me see where we at. Cause I know, let me see how far I'm gonna go. I'm gonna go to the two. I'm gonna see how much I can do. It's 10:52. I'm gonna see what I can do. Cause we might have to come back for part two. I'm sorry, y'all. I'm just trying to see. What am I doing all that instead of just doing this? Defendants must present briefs and support. Briefs and ooh. Oh man, they even listed. Oh baby, they was not playing. Oh my god. OMG, baby, this is juicy. All right, I'm gonna see. I'm gonna see how far I can get, and then we're gonna have to come back. We're gonna have to come back, baby, because I gotta get me some rest. I still got discovery I need to get out. All right, so let's tap on into this motion for a new trial in the brief. So it's a motion for a new trial, and then they put a brief in support. So they're that support pretty much is saying or provides all of the case law or evidence showing the reason why they need a new trial. Got it? Before we get to that, let me see. Oh, I am that. Somebody said hi. They've been talking a lot. Yeah, they can keep talking. All right. Miss Chantel said my husband and I are dealing with a biased judge on the civil injury case. The lawyer has made it clear that the judge told him that um the previous case, however, he is scared to what? We have been through a lot with this judge. He has shown bias in the motion. Are you guys licensed? Oh no, we're but here is the thing. I do so one of the attorneys, well, both of them that I contract with, one of them actually went to law school in Louisiana and they actually know some good folks in Louisiana. So, Miss Chantel, if you can message me on Facebook and I'm going to talk to the attorney and I'm going to see if I can get the other attorney's name so that way you can reach out to them. And let me tell you this, you can fire your attorney. If your attorney, now injury cases are a little bit different, but you can fire your attorney. The only thing you have to worry about, it just depends, and I'm assuming that y'all are already in litigation. They might sit there and take a fee. They might, what they call it. Oh my gosh, it's so late. I can't even remember what the crap they call it. They will have a fee. I can't remember. It'll probably pop up tomorrow when I get some rest. But yeah, message me on Facebook and I will get your information and then I'll talk to the attorney and see what attorney is in Louisiana so you can reach out to them. So I got you. All right. Motion for a new trial comes now. I'm not about to read that. We already read that other one. All right, introduction. This case presents a structural public trial violation. The court had authority to manage courtroom security, decorum, and capacity. But once it adopted and administered restrictions that foreseeably excluded members of the public from a high profile criminal trial, it was required to make record supported findings and to consider reasonable alternatives to closure. The court didn't either. The access regime limited public attendance to a narrow daily admission period, a small number of seats, and no continuing overflow or audio or video access after jury selection. See, if I would have went up there, I would have been pissed. Because that closure affected the trial proceedings themselves, and for the three additional grounds set out in this motion, defendant asked that the court to set aside the judgment and grant a new trial. In support, defendant shows the following. And see, the thing is, people are like, oh my God, they're trying to overturn the rule. Da 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 da. Y'all are about the slowest people I've ever like. Either you can't comprehend. They're not they're not going after the sentencing. They're going off of the courtroom procedures. All of the there's rules, there's statutes, there's laws that you have to follow, okay? They did not follow them at the end of the day. If you had a trial, I don't even care what case you had. If you went to trial and you can knowingly see that these people ain't doing what they're supposed to do, you have a right for a new trial. You would want somebody to be fair, right? So I don't understand what the big ordeal is. First of all, people got it incorrect. What we're actually wanting a new trial for. But because y'all are so small-minded and y'all can't comprehend, y'all just going off of what your ringmaster say. But let me get back. All right, so factual background. And what they say, this is getting juicy. I'll be back. If you do part two, you still have your own work to complete. Yes, ma'am. Yes, ma'am. All right. So the case and the verdict. This case arises from an altercation at a high school track meet. The defendant, Carmelo Sincere Anthony, was charged by indictment with the murder of Austin Metcalf, alleged to have been committed on or about April 2nd, 2025, in Collin County, Texas. The defendant pleaded not guilty. His defense at trial was self defense, that he used force that he used force he reasonably believed immediately necessary to protect himself. The court's charge submitted the offense of murder, the lesser included offense of manslaughter, and the law of self defense, including the justified use of deadly force. The defendant did not testify. I also did a reel that I think it's on YouTube and my social medias explaining the jury charge. Hold on, let me tell my kid to shut the. He getting on my damn nerves all the damn yelling. Hold on. Boy, I can't wait for these kids to go to college because goddamn, they're getting on my damn nerves. But anywho's, so if you have not seen the jury charge, definitely look. And the reason why I put that up there so everybody can see exactly, so they had to take the events and apply it to one of those three sections. And the way that they worded the jury charge, that's another thing. All right. On June 9th, 2026, the jury found the defendant guilty of murder and the court imposed a sentence of 35 years confinement. These matters appear from the indictment, the court's written charge, and the judgment. Okay? So again, it says these matters appear from the indictment, the court's written charge, and the judgment. This case drew national attention from the outset, and the court appointed a public information officer to assist with media credentialing, communications, and access logistics. In practice, public and media access were administered through that process. What follows is how that access was in fact administered. Before trial, at the perimeter of the courthouse campus, at the courtroom door, and after the verdict. They meant to put a, I had my mouse right there. Secrecy before trial, the gag order, chambers conferences, and no public pretrial hearing. Now that is interesting. So y'all was chit chatting in the chambers? That's a no no. The closing of this prosecution to public view began more than 10 months before trial. On July 28, 2025, acting sua sponte and on no party's motion, the court entered an order prohibiting extrajudicial statements, a gag order binding the parties, their attorneys, witnesses, the law enforcement personnel, courthouse and court staff, and court appointed officials, which by its terms remained in force through trial. Yeah, definitely go ahead and hit that like button if you have not done so. Share, share, share. Covered persons with firsthand knowledge were restricted from speaking publicly about the facts, evidence, witnesses, and expected testimonies absent written approval from the court. The gag order's terms were sweeping. Unless first approved in writing by the court, no covered person would make any extrajudicial statements that addresses the character, credibility, expected testimony, guilt, or innocence of any party or witness that discusses evidence anticipated to be introduced at trial, or that intends or is likely to influence public opinion and potential jurors. Restrictions expressly applicable to any public medium, including traditional news outlets and social media, and enforceable by contempt, fines, attorney discipline, or other remedies. Its findings were three sentences. The media coverage has the potential to imminent and irreparable harm to the defendant's right to a fair trial, that alternative measures such as venue change, juror screening, uh, what is that, sequestration, something like that, would be inadequate alone, and that narrowly applied speech restrictions as necessary to protect juror impartiality. No evidence is recited. The order permitted only procedural announcements such as hearing schedules, court filings, and statements required by legal or ethical duty, a safe harbor that presuppose filings the public could see. By its terms, it would yield only to further written order of this court, and the amended order later reaffirmed it until the completion of the trial. In the 10 months it operated, no person was ever alleged to have violated it, so far as public records reflect. The substantive pre-work, Lord Jesus, I need to go to bed. Pre-trial work of the case was then conducted out of public view. The parties' pretrial conferences with the court, including a May 21st, 2026 conference in chambers at which the parties' evidentiary understanding was described to the court, and a May 29th, 2026 meeting addressing trial, security, and scheduling occurred in chambers outside open court. Now, if y'all don't know how this goes, I'm going to give you the most recent example. Tyler Robinson. Tyler Robinson, the dude who allegedly unalived Charlie Kirk. That's not trial that they're having. That's like the preliminary hearings. If y'all follow me, Blueface. Like, you see these pre-trial things that are going on, right? That's early on in, like, y'all have to put two and two together. For Karmelo Anthony, they had it in the chambers. The pre-trial conferences was in the chambers. All right, it's neither here nor there. The parties' pretrial conferences with the court, including a May 21st, 2026 conference in chambers at which the parties' evidentiary understanding was described to the court, and a May 29th meeting addressing trial security and scheduling occurred in chambers outside open court. No reporters see, and that's why. When you do it in the chambers, the court reporter ain't there. So there's no records that exist. A matter the hearing will confirm. I remember there was one case. I think that was Young Thug. That was Young Thug case, if I'm not mistaken, where they were having, was it? I gotta go back. It was so many cases. These judges was having meetings in the chambers. I think it was. And then they was fighting to get that judge recused from the bench because of those meetings. I got to go back, but I think it happened in the Young Thug trial. Similar instance right here. Um, no pretrial hearing was ever held on the access restrictions, and the Register of Action reflects no such setting. The public docket discloses no motions in limine. Nope, I didn't see that either. And none of the substantive pretrial litigations, because there's pretrial documents that you have to file before trial, like witness lists, exhibits, motions in limine, all of that. I didn't see none of those except did I? I didn't even see the exhibits. But anywho, that's neither here nor there. Um, a member of the public who examined the docket before trial would have found no hearing to attend and nothing to read. Oh yeah, y'all. Y'all hit that like button, hit that like button, hit that like button. Okay, thank you. I know it was Young Thug. I know it was one of those cases. I was like, boy, it see when they don't want something to go on record, they do it in their chambers. Sussy, as my kids would say. The amended order, the written terms of access. On May 18th, 2026, the court signed the amended order regulating trial proceedings, media access, security, and courtroom decorum, entered to govern all aspects of the trial proceedings. The order recited the directives of Waller versus Georgia and Shepard versus Maxwell found that unrestricted access or activity may compromise courtroom security, juror privacy, and the defendant's right to a fair trial, and promise reasonable public access consistent with constitutional requirements. Yeah. And I think I showed that on my channel. I can't remember. But yeah, Brian still did go crazy. Brian still he was a I like him. Yes, they were skipping all types of legal steps. Mhm. In operative terms were these. The courtroom would open at 8:30 a.m. for the media and at 8:40 a.m. for the designated family members and at 8:50 for the general public. No more than 9 members of the media would be admitted. Seating would be on a space available basis. The doors would close promptly at 9 a.m. Well, that's a first. Individuals arriving after that time would not be admitted until a recess, and no person who left could re enter except at recess. All persons attending were required to dress in appropriate business attire. Hats and caps were prohibited, and clothing or items displaying messages, logos, symbols, and other images related to the case or otherwise distracting or potential prejudicial were banned. The order appointed Steve Stoller, identified in the order only by a personal email address and a cell phone number, as the court appointed public information officer, committed media credentials to that office and announced that the court will not intervene in or resolve disputes among members of the media regarding access or seating. Hold up. How you have a personal email address and you work for the county? Day one, you would have no, sir. The order contained no provision for an overflow room, an audio feed, a video feed, or any means of observation for members of the public turned away, and no mechanism by which a member of the public could be heard to object to any of it. The order also closed the courthouse grounds themselves. It placed the entire courthouse campus, including parking lots, I'm going sideways, sidewalks, green space, and other designated area under a nightly curfew from 11 p.m. to 6 a.m. beginning May 31st, 2026. It designated restriction zones on the attached exterior map, and it also ordered that the Collin County Sheriff's Office and other law enforcement personnel to ensure compliance with this order at all times during the trial. Under the order's enforcement clause, any violation, including a citizen's presence in the courthouse parking lot or on the green space beside the courthouse before 6 a.m., expose the violator to immediate removal from the courtroom, courthouse, or court grounds, and the position of sanction. What? Including contempt of court, and no warning is required prior to enforcement. No findings of any kind accompanied the curfew. Y'all crazy as what? Access and operation, the curfew, the parking lot, and the Don line. I just want to commend those who went out there because, baby, let me tell you something. I'm not getting on no 75 during them hours. I live right here in Richardson, and that's exactly why I moved. I moved to Richardson so I could be close to where I used to work. I work from myself, so I work from home. But baby, I'm not going down 75. So y'all, kudos to y'all who went up there. Child, I was still sleeping in my bed. In operation, admission had almost nothing to do with an order stated 8:50 a.m. public entry time. Because the public seats were few, members of the public began arriving in the pre-dawn hours, often between 4 to 5 a.m. before court was in session and while the campus curfew was still in force. Lord. And sheriff's deputies enforcing the order stopped arrivals at the parking lot and restricted entry onto the campus until the curfew lifted at 6 a.m. The queue that actually determined who would see this trial thus formed at the perimeter of the courthouse campus hours before any proceeding convened. A member of the public who appeared at the order's appointed hour of 8:15 a.m. had, as a practical matter, no prospect of a seat. The line itself was administered without published standards and not even-handedly. Individuals were permitted to move ahead of members of the public who had already waited for hours. Thelma Anderson, who arrived early on June 6 and initially held approximately the seventh position, was displaced to approximately 35th beyond the number of available seats and was excluded from morning proceed. What? Tamitra Carter, identified as number 7 on an early arrival list, was removed from the line on June 5th and lost the morning session. Admission was run through two lines, one for a media list, one for everyone else. And media outlets denied credentials were directed by the public information officer to seek entry through the public line, whereas a Collin County Sheriff's deputy administering the line acknowledged on video persons who print out whatever and make themselves like they are media consumed the public few seats, a practice the officers conceded they cannot police. That's wild. That is wow, bro. Inside the courtroom, 24 public seats and an overflow room provided and then withdrawn. The courtroom held approximately 70 seats, I'm sorry. By the court appointed public information officer on written account, 15 were allotted to the prosecution's family, 15 to the defense family, and 9 to the media, including a courtroom sketch artist, with additional seats for court staff, leaving about 24 or so for the general public. The trial judge later confirmed the arithmetic on television, some 200 requests by the media, and 27 to 32 public seats that re-rotated every day. None of these allocations appear in order, and the 15-seat family allotment was not honored in practice. The defendant's own family was limited to 8 seats in total, so that his grandfather and his aunts were excluded from his trial, while those admitted were required to register a day in advance and were warned that a visible facial expression could result in removal. I hope y'all read that. That's interesting. Hmm. For jury selection, the court furnished what its order had never promised: an auxiliary viewing location outside the courtroom, a functioning overflow room where members of the public who cannot be seated inside observed the proceedings on June 1st and June 3rd of 2026. On June 4th, 2026, the first day of testimony, the court eliminated it. No announcement was made in open court. No order was entered or modified, and no findings were made. Public access was thereafter confined to the seats inside. Nor was the elimination a reaction to anything that occurred at trial. As early as May 25th, 2026, the public information officer had advised an inquiring journalist in writing that there will be no overflow room during the trial. This, although the county's own media request intake form listed overflow room access among the accommodations that could be requested. When Thelma Anderson asked the court for an alternative viewing location, there were no way there was no way even to file the request. The county's electronic filing system had no category for a courtroom access request in a criminal case, so the request was routed by email to the court coordinator and on the public information officer, and it was denied outside any judicial proceeding. You know what? Hold up. I'm gonna take y'all on a journey. Cause baby, we about to see. Cause normally, um, really, y'all stuff. Oh, y'all see I'm work right there. East Texas. Cause I mean, I've never filed a media request, so I don't know. So I'm just gonna see exactly what the options were. Cause technically, the county can't hold on, let me see. Was that the case? I think that's the case. Technically, it's not like the county can just go in and make an option, but sometimes they're what's called a no fee document that you can possibly file under. But I know that, but I don't think the public will know that. But the clerk should know that. Hold up, let's see. Filing code. Let's see what filing codes they got. Affidavit, amending application, bond, electionist letters, motions, notice. I would have put it under other documents not listed or request. Yeah, I would have did that. But see, the public don't know that. The public don't know that. That sucks though. Um, Day by day, the accommodation existed only while no witnesses testified. The pattern is visible day by day. During jury questionnaires in voir dire, June 1st and June 3rd, an auxiliary viewing room accommodated the members of the public who could not be seated inside. On June 4th, the first day of testimony, that room was eliminated, and on every documented day of testimony thereafter, members of the public were excluded. The accommodation existed precisely when no witnesses was testifying and vanished precisely when the evidence began. Y'all know why they didn't want y'all in there when the witnesses was in there. Let me take a sip of my Coke. Hmm. Let's see, June 1st, jury questions, auxiliary viewing room was available. Oh, I mean, they got it down. Courthouse was closed on the 2nd. Voir dire, auxiliary room, testimony began. So anytime there was a testimony, it was, that's interesting. The excluded public. The exclusions that follow were repeated in concrete. Jacqueline Yan traveled from North Carolina and on the first day of testimony found a line of roughly 80 to 100 people, from which only about 27 were admitted. Tara Allen flew in from Arizona, observed jury selection from the auxiliary viewing room, was told on June 4th that the room had been eliminated, and was excluded from the courtroom on June 4th and 5th. Bridget Smith attended on June 4th, 1st, 4th, 5th, and 6th and confirms both the roughly 27 public cap and then the elimination of the outside viewing location once testimony began. Kiera, I hope I'm saying your name right, West, was turned away on June 1st on a purported jury members only rule and was physically removed from the courthouse on June 6th because of the expressive content of her clothing. Thelma Anderson was excluded on June 4th and 5th and 6th and was June 4th and 5th and on June 6th was seated only in mid-afternoon after substantial portions of that day proceedings had passed. Throughout, no declarant observed any disturbance, security incident, or disruptive conduct by any member of the public that would explain the restrictions. So y'all just like, what was the purpose of that? I'm saying if y'all can't reasonably see that these are accounts that happen. At first, they allotted 15 seats for the prosecution's family or the family of the victim as well as the defendant's family. But then they reduced their seats. Like there's a like if you cannot see this, then I don't know what to say. There's clearly something wrong with you if you don't see the issue with this. And then you have people that are coming in. Now, some of these names I do not know, but I bet you I'll know who was up in there. And I'm going to go see before I tell y'all, but I bet you she was up in there. Hmm. The unrecorded agreements. This is what people are talking about. This is the juicy one. I might read this and I might cut it off and go to bed. The unrecorded agreement. The defense tried its case under that limitation in reliance on an understanding reach off the record. The same off the record method that hid the pretrial proceedings from the public also produced the understanding on which the entire defense was built. Beginning in early May of 2026, the lead prosecutor proposed that the parties try the case clean based on what happened under the tent that day, with neither side offering character, reputation, or extraneous conduct evidence concerning either the Metcalf twins or the defendant. The terms were negotiated in meetings and calls on May 5th, 8th, May 11th, and May 21st of 2026. The parties presented the understanding to the court itself in chambers off the record. To avoid media reporting on bad act evidence, the understanding was memorialized only as a deliberately generic motion in limine hand delivered to the court on the first day of trial. It does not appear on the public docket. Oh, oh man. I want to go to example 10 and 2. I want to go to example 10. Oh my gosh, I don't even know where example 10 and 2 is. Hold up. Let me try something. We're going to use this find button. Exhibit. I hope this works. Please. We're on page 8. Oh, please don't. Okay, 4. Nope. We ain't gonna do it. Yay! Let's get into this tea right here. This is the affidavit of Mr. Trial Counsel Mike Howard, signed and notarized, y'all. Huh. We was on page 8. Y'all remember that? And I'm very, very interested because I work with a few criminal attorneys. Now, Mike Howard, now when we say criminal, everybody think, unaliving. Me, it could be DWIs, it could be all that. I thought he was just good for because every attorney, y'all have to realize all attorneys don't specialize in everything. Everybody has their strengths and then they also have their weaknesses. But a good attorneys know what their area of law is. In criminal, like, yes, you do have the unalivings, you have traffic tickets, you have DWIs, DUIs, assaults, like anything that you would get locked up for, right? For me, I thought Mike Howard just was good for DWIs and all that, not major stuff. Because I really don't follow him, to be honest. I follow like the Not Guilty Boys, Andrew. I've been following him for a while now. So I know of him. Like, if you ask me about a criminal attorney, I only have a few on my hand that I know because I've seen their work. But Mike Howard, I don't know. But let's see what he done said. Let's see what he said. Now, affidavit. Me, when we draft affidavits, this is something that it's a statement. Okay, it's notarized, and as a notary, when we notarize it, we have to ask them, is everything that you're saying in this true and accurate or correct? And we notarize it on that end. So based off of this, it is a notarized document that has been filed with this pleading. So if anything in this affidavit is not correct, he can get in trouble for that. Just FYI. All right. Well, let's see what he said. I was the trial counsel supported by second chair Toby Shook. Third chair. Oh, I didn't even know it was a third chair. Third chair co-counsel Tasha Gupta. Gupta. And briefing appellate co-counsel Michael Mwala, who represented Karmelo Anthony. Leading up to the June 1st, 2026 trial of this case, the defense and prosecution reached an agreement where the prosecution and defense jointly agreed to not raise an alleged character, reputation, or extraneous offenses, bad acts evidence relating to Mr. Anthony as well as Austin Metcalf and Hunter Metcalf during trial. That was the agreement. Hold on, let me see. Okay, and here, this is what it says. Alleged character. I want everybody, it's not saying that they both had, they all had something bad. It's alleged. Okay? Alleged. Keyword. The lead prosecutor in the case, Bill Worski, and y'all gotta go watch my little series, because Bill Worski, that dude is crazy in the office. He is crazy, he is disrespectful. And I think he be back blackmailing Greg. I'm not even gonna lie to y'all. But anywho's, the lead prosecutor in the case, Bill Worski, brought up the possibility of the agreement a number of times well before the agreement was discussed in detail and eventually reached. When mentioning a proposed agreement, Mr. Worski proposed that we try the case clean, which he defined as based on what happened under the tent that day, under the Memorial High School tent at Kirkendall Stadium on April 2nd, 2025, and not go into character, reputation, and extraneous offense and or bad act evidence applicable to either Austin or Hunter Metcalf or Karmelo. See, this right here, and I'm just thinking from my point of view from doing this, and this is my opinion. This is not saying that this is concrete. But by Bill Worski saying trying the case clean, I personally think that there was bad information out there regarding those twins, and he did not want that information to be brought up in court. And it could very well be something happened with Carmelo. We don't know. Cuz who else, I don't understand, why would you say let's try this case clean? Let's forget everything that they have done. That's why we didn't see the emails from the cheerleaders or anything of that nature. Because I'm telling you this right now, even in civil cases, we're pulling up everything on you. We're pulling up everything on you. So I feel it is the same in a criminal case. We're doing a background check. We are seeing, because we're going to try to use everything that we got. So by him saying, let's start this case clean. He didn't want to bring up all of that stuff because that would have looked really, really damaging on the prosecution side, right? Now that's just my opinion. I ain't saying it's concrete, but based off of what I have read about Bill Worski, and y'all will hear that if y'all watch inside the Collin County's DA's office, he's going to do any and everything to not have something get out. A little snippet into the Collin County DA's office, several complaints, several complaints from prosecutors, young prosecutors, tenured prosecutors about the actions of Bill Worski, about Greg Willis. And, and uh, these people report the HR. HR says we ain't never got the whatchamacallit. But Bill, behind closed door, people are sending a mass email to all the judges, the county commissioners, the staff. Everybody is getting these anonymous emails and letters regarding the acts of Bill Worski and Greg Willis. And he knows this. And guess what they do? They have these closed sessions behind doors to talk about it and to see what they can do so this shit don't leak out. Same thing here. He didn't want none of that to leak out because that would have been very damaging to the prosecution. It's right here in plain English. I can't say I'm making shit up because it's here. We're looking at it. I got the lawsuit with him and Greg Willis. Y'all can look at it too. They have a history of hiding shit. So he knew. He knew. And just think about it. If you have something damaging on the person that was unalived, right? You don't want to shed no bad light on. They have to continue to be the victim. And y'all don't even want to know what he said about victims. Y'all got to tune in. He said something about victims. Once this, I have to go see if it was published, if I already said it already. What he said about victims, I was like, bro, are you serious? But yeah, anywho's, I'm just gonna say this. He don't care about them victims. He don't care about them victims. I'm just gonna tell y'all that. On May 5th, 2026, Mr. Shook and Mr. Worski discussed this proposed agreement by phone. During that phone call, Mr. Shook and Mr. Worski discussed the evidence of character, reputation, and extraneous offense bad conduct as it applies to both the Metcalf twins and Karmelo Anthony. Mr. Worski reiterated that he would be happy to try this without getting into character at all, just on what happened that day at the track meet. Y'all see that? That right there just tells you. So, hey, both of them. The Metcalf twins got a history. Carmelo has a history. Now, how bad it is, we never know. But somebody has publicly came out and said that the twins were bullies. Yeah. Yes, they did. Exculpatory evidence. They did. Turn off the light. Oh, wait, no, when you finish, Dylan, when you finish. On May 8th, 2026, defense and prosecution teams met in the Collin County Grand Jury Room. The prosecution team gave us a document entitled State's Notice of Intent to Use Extraneous Offenses, hereinafter State's Notice, and we gave them a document entitled Anthony's Motion in Limine regarding the admissibility of pertinent character trait evidence, evidence under the ambiguous aggressor rule, and evidence under Texas Code of Criminal Procedure, Article 38.36, hereinafter defense notice. After tendering to each other our respective extraneous filings and briefings, we then discussed the proposed agreement, which Mr. Worski referred to as the gentleman's agreement. Mr. Worski outlined the proposed agreement as follows. Both sides try the case without character. reputation, or extraneous evidence for either the Metcalf twins or Carmelo Anthony, and just try the case based on what happened under the tent. So they don't want to bring up that that they were bullies or somebody might have gotten at the fight or whatever the case may be. They just want to base everything on what happened under the tent. And during another description during that meeting, what happened on the day of the incident. Seeking clarification, I asked, and Mr. Worski confirmed that this would mean that the defense would not go into evidence relating to the Metcalf twins' character, reputation, and extraneous offenses, acts related to violence and bullying, inclusive of discipline and write ups in the Metcalf twins school records within this framework, as well as racism. Do I need to read that again? I'm gonna read that again because this is an affidavit that was filed in this pleading. There are rules to filing affidavits, and you're lying. I just, FYI. I'm gonna read that again. Seeking clarification, I asked, and Mr. Worski confirmed that this would mean that the defense would not go into evidence relating to the Metcalf twins' character, reputation, and extraneous offenses and acts related to violence and bullying, inclusive of discipline and write ups in the Metcalf twin school records within this framework, as well as racism. In exchange, right? The prosecution would not go into character, reputation, extraneous offenses, acts, evidence relating to Carmelo Anthony, inclusive of contents of Carmelo Anthony's cell phone and school disciplinary records. At this meeting, I sought clarification on how this agreement would work practically, specifically, how to handle the possibility of opening the door to this evidence from either side. During this meeting, Mr. Worski repeatedly expressed his concern that the defense would kick open its own door by asking questions of witnesses that would delve into issues restricted by their agreement. I asked about specific statements made by witnesses interviewed by police and captured by video on the day of the incident, where those witnesses discussed the Metcalf twins being passionate, triggered, and not tolerating being disrespected, etc. Mr. Worski eventually agreed that questionings narrowly tailored to ask about specific statements and witnesses made to police about the incident under the tent on April 2nd, 2025, including statements just described about the mindset and actions of the parties involved in the incident, would not constitute kicking open your own door and thus would not violate our proposed agreement. During this meeting, we discussed the terms of the agreement being that testimony from eyewitnesses from under the memorial tent on April 2nd, 2025, and who were discussing the facts of what happened under the memorial tent on April 2nd, 2025 would be permissible, and that neither side would go into character, reputation, or extraneous evidence for either the Metcalf twins or Carmelo Anthony. During this meeting, I also asked about the agreement regarding the possibility of the defense calling experts, because that's normally what we do. We call experts. We have experts. Any video, any audio, medical records, vocation specialists, doctors, whoever. There's experts. Anywho's going back, so I asked how the possibility of the defense calling experts to testify during the guilt innocence phase would impact the proposed agreement. The prosecutor team relied that they had not considered us calling experts to testify during the guilt innocence phase. They stated that if the defense called experts to testify regarding Mr. Anthony's epilepsy or about a fight or flight response, they considered expert testimony like that to violate the agreement and thus open the door to character, reputation, and extraneous offense evidence. Y'all hear this? are y'all listening to this? Who said they are unable to hear? Michelle, I'm not sure what's going on. I know people are saying stuff, so I believe they hear me. If y'all can hear me, please put a one in the chat. I don't want to be up here talking to myself. Yeah, that good old boy agreement. Yes, definitely. If you have not hit the like button, please hit the like button here on YouTube. If you're on Facebook, definitely hit the like button. Share wherever you are. If you are on my true crime talk with your favorite paralegal channel, definitely hit the like button and share and subscribe. Awesome. Thank y'all. Thank y'all. Thank y'all. So they literally restricted evidence. His rights were violated. Colin County about to pay. Baby, baby. And I hope y'all can see the chat. I'll try to put it somewhere y'all can see it. But y'all are listening. Y'all picking up what I'm putting down. All right, let's get back into it. On May 11th, 2026, Mr. Worski, Dewey Mitchell, Mr. Shook, and I discussed the proposed agreement again by phone. I informed the prosecution that we had an informal agreement on the proposed agreement, but that we needed to have a final conversation with Mr. Anthony and his parents to confirm the final agreement. During this phone conversation, Mr. Worski confirmed that the agreement would extend to the sentencing phase of trial as well. Mr. Worski said that would mean that, in accordance with the agreement, the prosecution would quickly rest its sentencing case in chief without going into any of the allegations listed in the state's notice. Mr. Worski said, however, that he would not allow a false impression to be presented to the jury by a defense witness, and that if such a thing occurred, he would respond by going into character, reputation, and extraneous evidence from the state's notice. After the defense asked about an Anthony family member testifying at sentencing, Mr. Worski agreed that the agreement would cover Mr. Anthony's mother testifying to the standard, "I love my son, please show him mercy" type testimony, but that's it. Girl, this is wild. Yeah, I'm seeing this. I'm reading this motion. This is my first time reading this, y'all. I'm not even gonna lie to y'all. Cause what? And see, we was wondering, like, okay, well, why didn't they testify? Blah blah blah. Well, now we know why they didn't testify. Boy, boy, oh boy. On May 21st, 2026, the defense and prosecution teams met with Judge Roach in his chambers. During that meeting, both sides explained their agreement to the judge, describing it again as both sides agreeing not to go into character, reputation, or extraneous evidence as it applies to both sides during both guilt, innocence, and sentencing phases, as long as no doors are open or false impressions given. We agreed that the best way to document such an agreement would be for the defense to draft and file a motion in limine applying to character, reputation, and extraneous evidence applicable to all witnesses, so it would cover both the Metcalf twins and Mr. Anthony, but if made public, would not trigger reporting in the media about bad act evidence specific to certain witnesses, thus endangering a fair trial. On May 21st, 2026, I drafted the motion in limine as described above and sent it to Mr. Worski by email. It was hand delivered to the judge on the opening day of trial. Yeah, there is no I can pull up all of my cases that are in current litigation and we're about to go to trial, and we file a motion limine. I did not see I was like, where are the pretrial documents? I don't see any. And this is the reason. This is the reason. This, oh my God, this is crazy. The defense understanding of the agreement. Okay, let me see. I want to get through this. I want to get to this, y'all. I want to get to this. I know I see y'all comments and I try to put it up there on the screen. Yeah, it is. It's worse than we thought. So the judge knew about the agreement before. Mm-hmm. Mm-hmm. But see, here's the thing. Procedures. Why wasn't the motion to limine filed? And I can even go to the local court rules, and it shows you all the pretrial documents that has to be filed. Did Carmelo attorney feel that there was some damaging character issues against Carmelo to have them agree to that? Otherwise, that a bad crime. I think based off of what it said that inclusive to Carmelo's cell phone and what did it say? His cell phone and something. I can't remember. Oh yeah, his cell phone and school disciplinary records. Okay, whatever the case may be, he probably got written up for something. Hell, when I was in high school, I cussed out a teacher because, yeah, but I was a straight A student. She wasn't teaching me. But anything that he felt probably could be damaging, but I don't think it was more damaging than bullying and racism because that was clearly stated. Bill Worski did not want the people to know that they were bullies and that they were racist. It it clearly, I ain't say it. It just stated in this document that Mike Howard actually got notarized. Mhm. Man, and Greg Willis too. Greg Willis up there sexually assaulting women in his office. And I don't understand why people don't run again. I understand that Collin County is a very conservative county, but my God, that man has to go. If there are women in that office still being assaulted, and if Bill Worski is still belittling y'all, cussing y'all out, talking to y'all like y'all kids, leaving y'all excluded from professional development, trying to have a drinking time with his buddies, or freaking going to, y'all need to leave. Y'all need to leave. All right. So, anywho's, let's go back to this. So, this is what Mike's understanding was of that agreement. The defense understood the agreement with the prosecution to cover all witnesses who could be called to testify by either the prosecution or defense about the incident that occurred between Mr. Anthony and the Metcalf twins and their teammates under the memorial tent on April 2nd, 2025. Y'all notice that it says the Metcalf twins. So it didn't specifically say just Austin. So the incident that occurred between Mr. Anthony, the twins, and their teammates up under the tent. As every description by Mr. Worski described the agreement to allow for testimony about what happened under the tent, and Mr. Anthony was obviously a witness to what happened under the tent. By the plain meaning of the language Mr. Worski repeatedly used, the defense always understood the agreement to cover Mr. Anthony's potential testimony just as it would any other eyewitness to the incident under the tent on April 2nd, 2025. Following the plain meaning of Mr. Worski's word in describing the agreement, the defense understood the agreement to cover testimony by eyewitnesses, such as memorial students underneath the tent at the time of the incident, Hunter Metcalf, students outside the memorial tent who looked over and witnessed the incident, and Karmelo Anthony. Now, I understand some people be like, I don't believe. Now, Mike Howard, yes, I believe he's a joke. I think the best he can do is probably DWI, DUI cases, occupational license, that. Me personally, I even went to go see like murder trials that he actually covered. And to be honest, I went on Collin County and you could just type in the attorney's name and you'll see all of the cases. Me personally, if you and attorneys will tell you, if you ain't got no heat in that county, don't be taking no case. Do not be taking a case. Like when we file stuff, we be like, "What county is it?" Oh, it's in Collin County. All right, file it in Collin Court. They be dodging district courts because they was like, "I don't like the district court judges." They rather file it in county courts. But as far as this is an affidavit, and a notary has signed it. Whether we like it or not, he can get in trouble for producing a false affidavit. So everything, I'm taking this as true and correct because as a notary, and I hope the notary did that. Is everything in this true and correct and accurate? And he said yes. So I'm going to take this. All right. So, this understanding of the agreement was further confirmed by events that occurred after the motion of limine memorializing the agreement was drafted and tendered to the prosecution. On May 29, 2026, after the meeting with Judge Roach, the prosecution, and the defense to discuss how trial security would be handled, the parties discussed the timing of the state's case in chief and when the defense case in chief would start. Mr. Werski informed the court in defense that he estimated it would take 3 days for the state to present its case in chief, which would have ended sometime on Saturday, June 6, 2026. In response, I voiced concern to the judge in front of the prosecution team that some of the witnesses the defense anticipated calling to testify were unavailable on Saturday, June the 6th. I explained that, like in my case, I would not know until the final moment whether they would call our client for sure. But that if the prosecution rested sometime Saturday and the judge forced us to call witnesses immediately on Saturday, I may not have enough witnesses available to fill up a full day of testimony Saturday. I explained that. If this happened, it would force me to call my client out of order. The defense plan was to call all fact witnesses first to establish certain facts and then conclude by calling our client to testify as our last witness. Yes, there is an order. One day I might have to go through and kind of show you guys how the process works so y'all can see. On Friday, June 5th, 2026, the second day of testimony during the state case in chief, I checked in with Mr. Werski about how he was proceeding and whether he would end up making more or less time to present his case in chief that he initially estimated. Mr. Werski informed me that he was moving more quickly than he had initially estimated. Yeah, estimated. So the prosecution was on track to rest its case in chief midday Saturday. In this conversation with Mr. Worski, I again brought up the fact that several defense witnesses were unavailable on Saturday, and if the judge proceeded with his plan to force the defense to call witnesses immediately upon the prosecution resting in order to have a full day of testimony on Saturday, we might be forced to call our client out of order. This time, I did not preface the statement with the perfunctory that's a weird word. Like in any case, I won't know if I'm going to call my client at the last minute because I was not on the record and I was speaking frankly with opposing counsel. I was very plain about the defense intention to call Mr. Anthony to testify and how the judge's proposed schedule requirements were going to force us to call Mr. Anthony out of order. I don't independently recall what time on Friday, June 5th, this conversation with Mr. Worski occurred, but it must have occurred just before noon because I then sent an email to Michael Mola describing the problem we were facing and asking Mr. Mola to draft a brief for us to argue to the judge that he couldn't force us to call our client out of order. Yes, they do. Throughout the morning and early afternoon of Saturday, June 6th, Mr. Shook and I repeatedly check in with Mr. Worski to get updated estimates of when he might rest this case in chief, each time referring to how the judge's plan was going to force us to call a client out of order. Besides, the defense team repeatedly mentioned in front of Mr. Worski and the rest of the prosecution team, they were intended to call our client to testify, even if it meant it would be out of order. Mr. Worski's own actions and arguments made it clear that he knew full well that we intended to call Mr. Anthony to testify. Even both sides tendered their notices of and arguments in favor of the admissibility of character, reputation, and extraneous evidence pertaining to the other side's witnesses. Mr. Worski made references to understanding that the defense sought to introduce character and reputation evidence about Austin and Hunter Metcalf that was uncommunicated, unknown to Mr. Anthony via the ambiguous aggressor rule from Torres versus State. The ambiguous aggressor rule and the admissibility of uncommunicated character and reputation evidence of the decedent in a murder case are all part of a self defense argument. Torres discusses in depth how the ambiguous aggressor rule allows the defense to put on uncommunicated character and reputation evidence before or after the defendant testifies. Mr. Worski repeatedly brought up Torres in discussions with the defense team in the months leading up to trial, stating that while he thought the judge would rule correctly and not allow the evidence, he concluded that character evidence could be allowed. So you just see they all in it together. I'm telling y'all. And I'm not just saying this based off the Carmelo Anthony case. I'm saying this based off of that lawsuit against Greg Willis and Bill Worski. All them judges knew what was going on. Every last, even Greg Willis' wife. How can you be married to this man? All right. This repeated discussion of Torres and how it may apply to the trial showed that Mr. Worski was well aware of at least the possibility of Mr. Anthony testifying in order to argue self-defense. So he didn't want him to get up there to argue self-defense because questions will lead to questions and open up a whole can of worms, and then bam, that whole agreement that they have went to oblivion. This was the entire purpose of the agreement. In it, that it provided value to the prosecution. Y'all hear that? So the agreement provided value to the prosecution, limiting the defense from presenting damaging character and reputation evidence against Austin and Hunter Metcalf and the defense. From the defense perspective, the entire agreement centered around the defendant testifying without impeachment of character, reputation, extraneous evidence in exchange for the defense, not seeking to introduce character, reputation, extraneous evidence against the Metcalf twins. Furthermore, any competent criminal trial lawyer knows that for a self defense argument to have any chance of succeeding, the defendant must testify. For all these reasons, the defense always understood the agreement to include Mr. Anthony's testimony free of impeachment by character, reputation, extraneous offense, bad act evidence, just like every other witness either side could call to testify about what happened under the tent that day. So this is the reason Carmelo did not testify, because if he testified, then that would have opened up a can of worms for the Metcalfs, and that would have looked bad on the prosecution. That's pretty much what that's saying in a nutshell. The defense reliance on the agreement throughout the trial, the defense, and once I finish reading this, because I'm going on 12 o'clock midnight. Throughout the trial, the defense revised its trial strategy in reliance upon their agreement. Absent their agreement, the defense intended to cross examine each memorial student witness the prosecution called about Austin and Hunter Metcalf's character and reputation for violence, for being bullies, and for racism. The defense also intended to cross examine these witnesses about various statements they had made to the police on April 2nd, 2025, regarding Austin and Hunter Metcalf easily triggered, having a loud mouth, being passionate, not allowing themselves to be disrespected. Some specific examples include Austin's a really big guy, and he's kind of like the aggressive guy on the team. Austin got the same way that he got during the altercation, and the same way he got with some of us. And the mellow kid, something or whatever, and then Austin kind of got triggered. Austin and Hunter, they're not going to let you disrespect them. And Austin, like, he's like a big guy, so nobody really wants to fight him. And Austin, really a passionate guy. And Jose told police about Austin's history of fighting and almost getting kicked off the football team for fighting. I've known Austin for a while, and if Austin is about to get into a fight, you can tell. Austin can be a bit aggressive at times, and he has a bolder mouth sometimes. If the prosecution did not call any of these witnesses, the defense was ready to call them during the defense case in chief and question them of hostile witnesses. Furthermore, the defense intended to call witnesses familiar with Austin and Hunter Metcalf's reputation for violence and bullying. The defense intended to call witnesses who themselves were victims of the Metcalf twins' violence and bullying. The defense intended to question Memorial High School teachers about the Metcalf twins' disciplinary history contained in their school records, which corroborated their character for violence and bullying. And finally, the defense intended to elicit testimony about the Metcalf twins' arrest for racist graffiti. Y'all see this? Y'all get paragraph 15 right here? I might have to snip this and repost it because people need to know. Now, I'm going to say this. We may not like how Mike handled this case, but if he is a good defense attorney, as people say he is, please note that I believe he has all the records. When we do discovery requests and we request all of this stuff, then you already know that he has them. We already know that he was supposed to testify. Anthony was, Karmelo, but he couldn't. Y'all don't understand how Bill. We can make up all of this, but I have to base this off of everything that I have read in that other lawsuit. Who is that? Dane Calloway. Thank you. Thank you. Thank you. Thank you. I hope all is well. I need that document you're reading. My team reached out to you because I told them you do a great job and I would like to collab with you. Oh, thank you. First of all, thank you. Thank you. Thank you for the 100. Thank you for the being frank. Definitely. I'll be trying to do content. I'll be trying to hold it down. I have classes that I teach. Then I am a paralegal, so I do have a lot of work that I do, and then I do have kids, and I do like my alone time. But I will definitely reach out to you, and I will send this over to you, so that way you'll have it. But I will email you tomorrow when I get some time, so we can do some stuff. So, but thank you so much. You're awesome. Somebody said stop the tape. Y'all, oh my gosh. This is wild. This is wild. That is why Bill Worski did not want this to come up. This changes the game. This changes the game. I don't care. Y'all can say whatever y'all want. I'm probably gonna get on Facebook and YouTube and see all these hateful comments. But people who have it, when people have to what am I trying to say? My brain is leaving me. When they have to refer or defer to racist comments up under a post, that's gonna be crazy. That's crazy because you know what? It's the truth. And when you know something is the truth, you're gonna try to defer from that by calling me racist, uneducated, a fake paralegal, whatever. I am reading an affidavit from the defense counsel. And you want to know why I believe him? Because based off of what I read in another lawsuit about Bill, I believe it. I believe it. I'm gonna run 15 back. I'm a reread this back. If the prosecution did not call any of these witnesses, The defense was ready to call them during the defense's case in chief and question them as hostile witnesses. Furthermore, the defense intended to call witnesses familiar with Austin and Hunter Metcalf's reputation for violence and bullying. The defense intended to call witnesses who themselves were victims of the Metcalf twins' violence and bullying. The defense intended to question Memorial High School teachers about the Metcalf twins' disciplinary history contained in their school records, which corroborated their character for violence and bullying. And finally, the defense intended to elicit testimony about the Metcalf twins' arrest for racist graffiti. Hmm. Hmm. Yep. And so the judge knew this. You know why the judge knew this? Because they had that meeting behind in the chambers. So you already knew all of this. Baby, what? In good faith, reliance upon the agreement, the defense did none of this. Because he said, okay, look, if we're going to start a clean case and we're only going to include what happened under the attempt, just because, and he shouldn't have done that. I will never, I don't think you'll ever catch a good criminal attorney to say, hey, okay, I'm gonna make a deal with you. Hell, we don't even do that in personal injury cases unless you're talking about settling our case. That's the only time we're gonna talk to you. But I would never, ever, ever, ever sit there and make an agreement with the prosecution in a murder case. Absolutely not. Whew. The defense even limited its questions of witnesses about statements they had made about Metcalf twins being triggered, having a loud mouth, being passionate, etc., that had been deemed to be allowed under the agreement in an abundance of caution to avoid opening the door. Furthermore, because the prosecution had made it very clear that the defense calling in any psychology related expert would open the door to character, reputation, and extraneous evidence pertaining to Carmelo, the defense choose not designate any experts and ultimately choose not to call as a witness a neuropsychologist to discuss how Mr. Anthony's epilepsy impacted his perception of threat and response as that is relevant to self-defense, and a forensic psychologist to discuss both brain development of a 17-year-old as well as a fight or flight response as it applied to Mr. Anthony's actions. So, boy, Bill knew what he was doing. Mike didn't want to stand up to them. I'm just going to come out and say it. He didn't want to stand out to them. He did not want to stand up. And I hate, and I'm just going to say this out loud and he get mad. I don't know if he remember me or not. But Mr. Dominique Alexander, I hope you did not tell that family not to hire the not guilty boys. I pray to God, I hope you did not tell them that. You are going in Collin County, the most conservative county in this region, and you're going to tell them not to, like, I don't care. You need somebody that can go toe to toe, who ain't scared. And I know Andrew ain't scared, baby. They held Andrew in contempt. One time he was cheesing in that damn mugshot. You need somebody to go toe to toe with these people. I mean, whether or not, like, they're like, dude, we got to do better. There's like, you really just like you, but knowing how Bill is, though, ain't no telling what the fuck Bill did. Because, like I say, I really think Bill got dirt on Greg Willis and Greg Willis got dirt on Bill. So I'm pretty sure Bill got dirt on anybody on any and everybody, and he uses that. Like, these people in that DA office, Bill and Greg, literally made it to where this one chick, she was barely making it. She quit. Like, I'm not even gonna tell y'all. Y'all gotta tune into that. But I'm gonna tell y'all this. They have power. If they tell you that you ain't gonna be able to work in any court, any city, any county, they were doing it. So I don't know what he told Mike, but this is fucked up. This is fucked up. Whew. Furthermore, because the prosecution had made it very clear that the defense oh, you already read that part. All right. Oh, come on. Come on. I think my computer about to give out. Wait, where we at? All right. As a result of this revision in defense strategy, the defense did not go into these subjects during the voir dire opening statement. Without such an agreement, or if the defense had suspected that the state would violate the agreement, the defense would have explored the subjects during the voir dire. And yeah, I know I am a paralegal. Some of this shit I do not know how to pronounce, but baby, I know what it is, so y'all leave me alone. And would have introduced those topics during its opening statement. And if y'all have not liked this video, y'all better like it on YouTube, on both my channels, as well as Facebook. I will come for y'all. In sentencing, in reliance upon the agreement, the defense did not designate an expert, oh my gosh, who was ready to testify regarding mitigation, a risk management, a risk, I said risk management, a risk assessment and psychological profile of Mr. Anthony. Furthermore, in reliance upon the agreement, the defense severely limited its available character witnesses to 3 questions of Mr. Anthony's mother, which had been previously agreed upon by the prosecution. Because remember, they told her she just got to say, I love my son, or some stuff like that, and that's all. Other than general character testimony and pleas for mercy, in reliance upon the agreement, the defense also did not go into substantial family violence Mr. Anthony had witnessed and been a victim of in his home. Wait a minute. Other than general character testimony and pleas for mercy, in reliance upon agreement, the defense also did not go into substantial family violence Mr. Anthony had witnessed and been a victim of in his own home. Child. Now that's some tea right there. Notification of breach of the agreement. All right, I'm trying to power through this. On Saturday, June 6, 2026, after the prosecution rested its case in chief, the defense called witness Adam Linwood, Jeremiah Smith, and Jose Andre Ramos Mora before ending the day in the late afternoon, early evenings. On Monday, June 8, 2026, the defense resumed its case in chief, calling Brendan Stephens and Brandon Lacey. The defense next planned witnesses, and that's redacted, had been avoiding the defense subpoena and kept changing the time he told us he would arrive at the courthouse. Accordingly, after Mr. Lacey's testimony, we took a break at 10:50 a.m. to see if blank had arrived. Now, if it's redacted, that means that that's probably somebody under the age of 18, and minors have to be redacted from the court filings, especially if it's going to go public. During the 10:50 a.m. break in the back hallway outside the judge's chambers, the judge asked us for an update about timing, how many more witnesses, etc. I explained that the next witness the defense had planned to call was a Centennial High School coach, Centennial High School coach. Mr. Worski asked what the coach would testify to that did not pertain to Mr. Anthony's character. I explained that this coach had witnessed Mr. Anthony's seizures, so he would testify about Mr. Anthony's epilepsy based on his personal knowledge. Mr. Worski then argued that testimony about epilepsy was irrelevant at guilt, innocence, and to the extent it was relevant, would open the door to character, reputation, and extraneous evidence against Mr. Anthony. In plain terms, it would breach the agreement that they had. I stated that I disagreed. let me describe. I stated that I disagreed, explaining how it was relevant to Mr. Anthony's state of mind pertaining to self defense and that it did not relate to character, reputation, or extraneous evidence in any way. But Judge Rocher agreed with Mr. Worski that he, through testimony about epilepsy, was not relevant during guilt, innocence, and would open the door to character, reputation, and extraneous evidence. Based on this, I informed the court that I would not call the coach and that I anticipated having one or two more witnesses before I would call Mr. Anthony. In response to the judge's questions about likelihood of Mr. Anthony testifying, I told, let's see, wait, I told the judge that we would need to confer with Mr. Anthony about his Fifth Amendment amendment decision regarding testifying, but I was 99% sure that he would in fact testify. After the break, back in the court before the jury to give blank more time to arrive at the court, we then called Frisco Police Department Detective Riley to testify. After Detective Riley finished testifying, then I decided not to call blank as a witness, and we broke for lunch early around 11:17 a.m. And the prosecution and defense teams stayed behind to talk to the judge outside the jury's presence. On the way back to the chambers, Mr. Worski mentioned to Mr. Shook that, from his perspective, I had already opened the door to character, reputation, and extraneous activities, Lord, extraneous evidence pertaining to Mr. Anthony by saying that Mr. Anthony was a member of the chess club during my opening statement. I did not say anything about chess club at any time during my opening. I said that Mr. Anthony played chess during my background description of him and his hobbies. Oh, so he didn't want people to know Anthony played chess because that would mean he's very intelligent. I like chess myself. Mr. Worski also stated that from his perspective that the agreement did not cover a testifying defendant. Mr. Shook alerted me and Mr. Worski, Mr. Mitchell, Mr. Shook, and I stood in the well of the courtroom, and Mr. Worski repeated these statements, adding that the prosecution never thought that the defense would call Mr. Anthony to testify. Back in the judge's chambers, Mr. Worski repeated his assertion that the agreement between the prosecution and defense never contemplated a testifying defendant. He elaborated, saying that he had never thought we were calling Mr. Anthony as a witness. He also repeated his claim that I had already violated the agreement during my opening statement by saying that Mr. Anthony was a member of the chess club. It is important to note that this was the first time Mr. Worski mentioned that he believed I had violated the agreement days earlier by mentioning that Mr. Anthony played chess during my opening statement. Although the prosecution and defense team had conferred many times throughout the prosecution's case in chief about various issues, this was the first time Mr. Worski brought up this assertion. Baby, 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 baby. Judge Roach told both the prosecution and defense teams that my mentioning chess during the opening statement definitely did not open the door to character, reputation, and extraneous evidence applicable to Mr. Anthony. The parties argued about whether the agreement between the parties covered Mr. Anthony's testifying. The prosecution repeated their position that it did not, and that if we called Mr. Anthony to testify, character, reputation, and extraneous evidence pertaining to Mr. Anthony were in play. Furthermore, Mr. Worski stated that time, at that time that the prosecution already had rested character, reputation, and extraneous evidence pertaining to Austin and Hunter Metcalf was not relevant. When Mr. Shook and I mentioned that the ambiguous aggressor rule from Torres, Mr. Worski argued that Torres did not apply because it was not ambiguous who the first aggressor was, that the first aggressor was clearly Austin Metcalf. At this point, the discussion devolved into a shouting match. Lord have mercy. Impact on the defense case. After the breakdown of the agreement, the defense and prosecution teams agreed to take a 10 minutes to cool off before attempting to renegotiate parameters for how the agreement could extend to Mr. Anthony's testimony should the defense now choose to call him. After the 10-minute cooling off period, Mr. Worski and I met in open court outside the presence of the jury and without the public in the room to discuss possible parameters for the agreement covering Mr. Anthony's testimony. Given Mr. Worski's expansive view on what he considered would open the door to character, reputation, and extraneous evidence pertaining to Mr. Anthony, especially his repeated claim, even after the judge stated otherwise, that even my mentioning of playing chess opened the door to character, I resolved that my only choice was to go over my planned outline for Mr. Anthony's direct examination by line with Mr. Worski to determine what would and would not, in Mr. Worski's view, open the door. Baby, what? I have never taken such drastic step of previewing my strategy and even my questions with a prosecutor. But as a defense team, we agreed that we had no other option if we wanted to try to reach an agreed understanding with Mr. Worski of how renegotiated agreement would cover Mr. Anthony's testimony. Mike Howard, why the fuck would you do that? I would not have done no agreement. Fuck Bill Worski. Like, seriously. You did not have the balls to stand up to this man. Why? This is crazy. Oh my gosh. As I went through my outline with Mr. Worski standing, reading the outline over my shoulder, Mr. Worski declared various subjects that, in his view, would open the door to character, reputation, and extraneous evidence pertaining to Mr. Anthony. During this discussion, Mr. Worski repeated his claim that my earlier mention of this man in this damn chess club opened the door. While I disagree with all of Ms. Worski's assertions of subjects that would open the door, I agreed to cut them from my questioning in the hopes of salvaging the agreement to keep Mr. Anthony's extraneous offenses out if he testified. I need to know exactly what was in those records that you felt. Well, I guess here's the thing. I don't think he wanted, regardless of what Karmelo did, what was in his records, that would have opened up the door for them to talk about the twins. I fuck it. I would not have came to an agreement. This is why I gotta go to law school. I can't. This is wild. At the end of this discussion, with the understanding that Mr. Worski would extend me leeway to lead Mr. Anthony more than normal through certain aspects of the testimony in abundance of caution to avoid opening the door, Mr. Worski and I informed Judge Roach that we had come to an agreement as to how the renegotiated agreement would cover Mr. Anthony's testimony. Again, y'all doing what? We then summarized the process we had just gone through in our renegotiated agreement on the record. Oh my God, this is crazy. Prior to breaking to allow the defense to retire to the defense room to discuss the issue and Mr. Anthony and his parents, Judge Roach informed us that he was aware of no mechanism at his disposal to enforce the agreement between the parties. Furthermore, Judge Roach informed us that he saw no way for Mr. Anthony to testify without the door being open. For example, if he said that he brought the knife by accident or said that he was scared, etc., that this would most certainly open up the door to character, reputation, and extraneous evidence of some sort. To clarify the issue, I proposed the hypothetical scenario that if Mr. Worski claimed that the agreement had been breached in some way, if I or even the judge felt that Mr. Worski was operating in bad faith, that the judge was stating that he could not enforce the agreement, would have to make a ruling based on the Texas rules of evidence alone, and that in all likelihood the door would have been opened. Judge Roach confirmed that this was the case. We then broke to discuss the issue with our client. Judge Roach gave us approximately 10 minutes to explain the breakdown of the agreement and propose resolution with our client before the judge brought Mr. Anthony in for an on record admonishment. What? During the initial admonishment meeting with Mr. Anthony and his parents, I did my best to explain everything that had just happened with the help of Mr. Shook and Miss Gupta. Then we returned to the courtroom for Judge Roach to admonish Mr. Anthony about his Fifth Amendment rights and also explain that if he testifies, Judge Roach believed that he had no mechanism to enforce the agreement between the parties and would rule on the rules of evidence alone as to whether the door had been opened. Judge Roach then gave us 10 minutes to discuss his Fifth Amendment rights with Mr. Anthony and help him ultimately decide whether he would testify. I asked for additional time to have such a complicated discussion with a 19-year-old in the most stressful situation of his life, but Judge Roach declined to extend our time beyond 10 minutes. Again, we did our best to explain everything, the pros and the cons of testifying versus not testifying. The likelihood of winning on self-defense if he testified versus if he did not. The likelihood of whether we would get instructions in the jury charge on a lesser included charges of manslaughter and criminally negligent homicide if he did and if he did not testify, and the likelihood of whether we could get instructions in the sentencing jury charge if we got there on sudden passion if he did and if he did not testify. During this discussion, beyond all of the above, the most complicating factor of all was whether Mr. Worski would claim that we opened the door and then bring in Mr. Anthony's extraneous offenses, bad acts, character, and reputation. Based on his actions and claims, specifically his repeated assertions, even after the judge had firmly disagreed, that I had opened the door by even mentioning chess, as well as general claim that the agreement had never contemplated Mr. Anthony's testifying, despite the plain meaning of the words Mr. Worski himself repeated used to describe the agreement. The defense team felt strongly that the risk of Mr. Worski claiming the door had been opened was too high. This was amplified by the fact that Judge Roach made it clear that should Mr. Worski claim a breach of the agreement, he felt he was unable to enforce it and that in all likelihood the door would have been open. At the end of 10 minutes, despite our request for additional time, Judge Roach called us back to the courtroom to announce Mr. Anthony's decision and proceed with trial. Poor Jesus, Lord have mercy. To the person, oh, well, we don't know. We don't know. All it said was cell phone and his school records. So it probably wasn't nothing. Because, like, here it actually told us what the Metcalfs did, like bullying, racism, and something else that they said. And the teachers was saying, like, all that stuff. But for Karmelo, they only mentioned the cell phone, or it says inclusive to the cell phone and his school records. So I don't think it was as severe as the Metcalf twins. Ultimately, Mr. Anthony chose not to testify. So here's the thing. Oh my God, I see everybody's comments. Okay. Ultimately, Mr. Anthony chose not to testify. So Karmelo said he don't want to testify. Now, y'all have to remember, he did not have enough time to explain everything, right? He didn't have enough time. So he's never been in trouble, especially to this extent. I could sit here and explain that to my 20-year-old and my 18-year-old, and they ain't never going they're I can't say they ain't ever going to get it. I mean, they're going to have some inclination as to what it means, but they're not going to fully understand because they never been in trouble before. You see what I'm saying? So you have a kid that is on trial for murdering somebody, and you not allowing them to have enough time so that they can actually understand what it is. So hell, he probably was scared and said, I don't want to testify. And that's right. You are absolutely right, Jazzy. But this goes to show that Mike should have prepared him for all possibilities, for all outcomes. So that way he could understand, at least by the time you get to this point, he could be like, okay, yeah, I remember we talked about this. So, okay, I kind of understand what you're saying. But there was no true preparation. Ultimately, Mr. Anthony chose not to testify. This 180-degree change in the defense strategy was a direct consequence of the breach of agreement. The breach of the agreement affected all aspects of the defense case. By the time that the agreement was breached, it was too late to change our approach in voyeur dire, Lord Jesus, an opening too late to ask different questions of the prosecution witnesses, and too risky to recall those witnesses to ask questions that would risk the prosecution deciding we open the door. It greatly hampered our strategy during sentencing, causing us to decide not to call witnesses we otherwise would have called, and severely limiting the questions asked of the one witness we did in fact call. The prosecution's breach of the agreement directly and significantly undermined the defense's ability to present a complete defense. So, by Karmelo not testifying, that's one thing, but not allowing the witnesses that he had lined up and the experts, those are the biggest two things. The people who were there, character witnesses who knew of the twins' behavior, teachers, as well as experts, did not get to testify. Bill knew what he was doing. Bill knew what he was doing because that's the type of person he is. He's a bully himself. Bill is a fucking bully himself. So I'm gonna put a pause in there, y'all. I'm gonna put a pause in there because this was the affidavit. So we was on page 8. Y'all, I gotta figure out when I'm gonna come back tomorrow and finish. But we read the affidavit. We just read the freaking affidavit. Was I on page 8? I think I was on page 8. Yeah, because I went to exhibit 10. Yep. All right. So we're gonna come back tomorrow and I'm gonna finish this. But hey yo, I think we got through a lot. I think we got through a lot already, y'all. I really think we got through a lot. Um, I'm shocked. I hate that this thing does that. Y'all see me doing all this. I'm really shocked. Um, in my opinion, I felt like Mr. Howard could have stood up to them. Why he didn't, we will never know. We will never know. Y'all, like I said before, please like this video. Please subscribe to my channel. If you're on Legal Doc Talk, subscribe. Head over to True Crime Talk with your favorite paralegal. That's my other channel. Get my subs up over there. Like and share. This is deep, and we're not done. We need to figure out everything. So we already know what was going on and what happened because Mike just told us. Mike Mike just told us what happened. I know we don't like Mike, but Mike just told us what happened behind closed doors. It's very disturbing. It's very disturbing. And like, no, I'm not an attorney, but I do work in the system, and this is fishy. Everybody needs to stop saying, and I'm not talking about everybody that's tuned in right now or chatting with me in the chat, but y'all have to understand this is not about the sentence. This is about courtroom procedures, things that were done that should not have been done. There are procedures that you have to follow, judges and attorneys, down to the people in the freaking courtroom. Therefore, he had a right to appeal, because appeal is about procedures. It's not, we're not disputing the facts. We're disputing what happened as far as procedures in the trial court. This is crazy. This is crazy. But y'all, it's about to be 1 o'clock in the morning. And I am tired. I need to get me some shut eye, because I'm probably gonna wake up early and get some work out the way, so that way I can chat with you guys so we can finish this up. I'll probably do it probably in the evening. I don't know. But definitely let me know what time works best for y'all. If y'all want me to do it at 6 or 7, I don't know. That way I can cook for my kids prior to that, and I'll probably do it at 6. No, because my video come out at 6. I'll figure it out, but I'm sure y'all will tune in. Oh, y'all, I'm hollering. You know what? Hold on, let me, before I show that one. Thank you for sharing your heart. Thank y'all for tuning in with me. Thank y'all for staying up with me. Everybody who sent over I don't know how, some funds. I think that's how you say it. Whether y'all did a super chat or I'm not too, I don't know how you would word it on here, but everybody who contributed to the channel, thank you. I do appreciate that. I really do. But going to this one right here, be sure y'all head to Mike Howard's Law page and leave a bad review and 1 star. We are on a mission to bring his rating down. I'm hollering. And on that matter, I am going to bed. But y'all, once again, like, share, subscribe, head over to Facebook. I think my Facebook is Legal Doc Talk. My Instagram is Legal Doc Talk. TikTok is Legal Doc Talk. I think. But if not, just go in my description and y'all find all my social media that's there. But until then, y'all, I will see y'all tomorrow. I will try to set it up early so that way everybody will be on one accord. We're not going to be up till 12 o'clock midnight. Some of y'all is probably 1, some of y'all is probably 9. I don't know. But good night. Oh, let me see. Will he receive, well, okay, and before I do that, here's how this works. It's not, there's steps, okay? So we have to see how this motion to recuse and motion for new trial is going to play out. Mind you, they have 75 days to rule on that. If it doesn't rule in that favor, then the appeals process will then continue. And with that being said, they have, so the court record from the trial court, as well as the transcript, has to be submitted to the Fifth Court of Appeals. Once the Fifth Court of Appeals receive both the transcripts and the clerk's record, then it's forwarded to the appellate team, and then the appellate team has to draft a brief. And that brief is very intense. I think I covered a video kind of explaining what all a brief entails. And then once they submit their brief, they can also request an oral argument to go before the 3-panel judge, or a minimum 3-panel appellate court. But once they submit their brief, then the appellee, which is the state, have to submit their brief, kind of like a response to the appellant brief. And then once they submit their brief, the Fifth Court of Appeals will allow the appellant, which is Karmelo's team, to respond to that brief, to the appellee's brief. Now, if there is any oral arguments that are requested, there will be an oral argument hearing that they would have to go before the panel. And then after that's concluded, then the panel will take the briefs and everything that's in the oral arguments, and they will make their decision. So they have to go through all of the facts, go through the briefs, go through everything to come up with their opinion on whether they think, whether it's overruled or affirmed, in simplest terms, whether the standing in the lower court is going to stand, or they're going to say, okay, we did find errors, we're going to how we say that, they're going to say, okay, we believe that there should be a new trial because we found errors, so on and so forth. So we have to wait. Now the appeals process is time. It's not something that's going to be in 2 months, 3 months, 4 months, 5 months. I showed an example in the case in Allison case out of Bell County. That is in the 12th Court of Appeals, I believe. And just a couple of weeks ago, on June 18th, the appellee finally submitted their brief, and they filed for their notice of appeal back in 2025. To be exact, I think it was July of 2025 when their notice of appeal was, and the appellee is just now submitting their brief in June of 2026. So it's not going to be an easy process. It's not going to be easy. It's going to be long. But time is something that we all need to be thankful for, because this gives them time to really get into these transcripts and these clerk records and look at the actions that the courts took, and to actually apply that in these briefs. So don't be so quick to rush them to try to get this stuff moving. It's going to take time. We all want the same thing. We all want Karmelo home. We do. And I pray that we can at least get him home while this is going on. But everything has to play out. Okay. So I hope that answered your question. No, it's not an automatic appeal, because appeal is a process. We're the goal is to get an opinion from the appellate court as to if there were any legal errors in the trial court. Okay. All right. So again, yeah, I think I'll talk about that tomorrow. How to, write a letter to the bar, how to file a complaint with the state commission, with the judges, and all that other stuff. Because you guys are able to do that. Okay. And as far as the state bar, um, with the state bar, it's a little bit tricky because I tried to do that on an attorney who didn't pay me, and they denied. I was like, wait, what? So certain things that you can send to the state bar, I think by us just saying, we don't think that would have to come for their family. But that's we'll talk about that tomorrow. But once again, good night. Thank you for tuning in. Like, share, and subscribe to all of my channels. Follow me on social media. I will see y'all tomorrow. Peace and love. Good night. Blessings to all. Bye.